Good morning. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Daryl C. Casanueva, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Good morning and welcome to this session of the Second District Courts of Appeals remote oral argument. The cases that are scheduled on our docket today will be called in the sequence that they appear. Just in case there's any surprises, I will let you know that the fourth case on this docket, CAFRA and State Farm, settled last night. So if there's anybody here, or at least it resolved the need for an oral argument, let me be more precise. On that case, it will not be heard today at the request of the parties. That being said, we will handle the remaining cases in the sequence that they appear, and likely the time for the second session has only one case. When each case is called, it's my understanding that there will be a brief pause while you are transitioned into our virtual courtroom. So please bear with us. And after each case is completed, the participants will be asked to leave the meeting, but are allowed, if they so desire, to watch it at a different location, at a different place on terms of the online feed. I will remind the parties that the appellant is awarded, each side is awarded 20 minutes. The appellant is able to reserve up to 5 minutes for rebuttal. Would you please let me know, if you are the appellant, how much time you would like to reserve? But don't worry, most likely I will prompt you for that question, as I will be the one required to notify you when you're about to invade the corpus of your time for rebuttal. Please remember to unmute your microphone when you are recognized to present your argument. With that being said, we will begin our docket today with the cases of the case of law offices of Kevin Ambler and Ernest Dwayne Davis et al. All right, we have one counsel. We have Mr. Ambler. Is Mr. Howard with us today? Or Mr. Ambler, will you be making argument?
I'll be arguing, sir.
Okay. And Mr. Ambler, how much time would you like to reserve for your rebuttal then?
5 minutes, Your Honor.
Okay. Thank you, counsel, and you may proceed.
Thank you very much, Your Honor, and may it please the court. Judges, I am here today to argue on behalf of the appellant Ambler Law Group and Kevin Ambler on a non-final order that approved a confidential third settlement in a medical malpractice case. The case, just by way of brief facts, arose back, or representation began in the case back in April of 2011. The medical malpractice claims were investigated through June of 2013, and a suit was filed in that year. In July of 2016, there were 13 defendants, and a settlement was reached with a couple of those defendants involving an individual and an entity he worked for. And that settlement was approved by the court in July of 2016. That's at your appendix 158. Subsequently, the case was set for trial. And in October 2017, the appellee had notified the Ambler Law Group that it was terminating representation in the case. Thereafter, on November 15th of 2017, the trial court entered an order substituting counsel, and the case proceeded. There was very limited discovery. Expert reports were already issued in the case prior to the termination of representation by Ambler Law Group. And in March of 2018, a second settlement was entered into.
Sir, I'm sorry to interrupt, but you can use your time however you want, but we are familiar with the facts of this case.
Let me go right then to the issues before the court. In summary, this is one of those instances where, to use the euphemism, it was a cart before the horse. The court conducted a hearing on June 25th of 2020, in which in attendance.
That was the hearing to decide whether to approve the settlement?
Yes, ma'am. The confidential third settlement in the case. The important point for the court, as noted in the reply brief, is that there was a there was a confidentiality order already in place that the court had entered in May of 2020, which permitted the Ambler Law Group to share in confidential information on the case, attorney-client privilege information, and a variety of other issues. And
Well, your
so,
complaint is that you weren't able to participate in that hearing, correct?
that's part one. Part one is we weren't able to meaningfully participate in order to object because we didn't know what the terms were of the third settlement that was being proposed to the court. But more importantly, the court entered an order on June 26th of 2020. And that by that order, the court authorized disbursement of the funds.
But that was the disbursement later, that was changed, wasn't it? Isn't the money now being held in trust?
Well, I'm sorry, that point is a bit unclear. The disbursement of whatever is there may be held in trust. That concerns the first and the second settlement. So there is the matter of approximately 1.5 million that was already being retained in trust in the trust account for the Ambler Law Group and for the trust account of the substituted counsel for Appellee. But the amounts for the third settlement are unclear whether those are in trust or whether there are sufficient funds in trust. And that goes to the core issue here, is that there was a predetermination that the amount being withheld was sufficient to cover charging lien that has never been adjudicated and gone to a final evidentiary hearing.
But that was based on your stipulation as to the appropriate amount to be held in trust, wasn't it?
No, ma'am. We did not stipulate to an appropriate amount.
You never said.
Go ahead.
You never said that 1,300,000 was enough based on your calculations?
No, I would refer Your Honor to the appendix, page 257, where counsel for Ambler Law Group points out for the court. This is in the transcript from that hearing.
Which hearing? Which hearing?
Yes, this is the hearing on June 30th, 2020. It was the hearing for reconsideration.
Well, that was later.
Yes, that was later.
Originally, you submitted, I can't recall offhand when it was, but at some point you said 1,300,000 would cover your attorney's fees. Now you are arguing that was just a preliminary determination, and you've done more calculations, and now in your view there should be almost 3 million held in trust. But originally you said 1.3 million, didn't you?
What was said was there was a preliminary calculation. The calculations were still being determined in terms of the amount of hours, and in the early filings there was a preliminary determination of 1.3 million. That was later revised. And I point out to the
when
court,
was that? When was that later revised? Did you filed a motion to?
There was a motion for enforcement of the charging lien that was subsequently filed in May of 2020, in which those numbers were clarified from the original numbers of 1.3 that were filed at the notice of charging lien.
Was that after for some reason I can't find the dates
that was
in my
before
notes.
the hearing. That was before the hearing that was conducted on June 25th. There was a motion for enforcement that was filed in May of 2020, a month before the hearing that the court conducted. And I would point out for the court that, by this the Supreme Court has held very clearly in the Shearsey et al. Versus Pollitt's case from 1995 that charging liens are determined by the totality of the circumstances for quantum merit, not just based on lodestar. And in this case, the quantum merit.
There's nothing that's occurred that prevents you from litigating your charging lien, is there?
The issue is not whether we were prevented from litigating the charging lien. The issue is whether the fund that should have been impressed and frozen is sufficient to adequately protect the charging lien prior to there having been an evidentiary hearing and final determination of what the amount of the charging lien is. And in this instance, we're arguing that there's a form of prejudgment that's occurred in looking at the numbers of what's already was in trust and not knowing what the amount of the third settlement was. And the court.
Yeah, but all the court did was just approve the settlement, correct?
No, the court approved the settlement and ostensibly a disbursement of some of the funds. The issue that we raised an argument for.
But as I understand your issue, you are arguing that you should have been able to object to the settlement.
Yes.
That has nothing to do with preserving funds to satisfy your charging lien.
So let me elaborate on that, Judge Kelly, because that's a great point. And here is how it ties into the due process argument on the opportunity to be heard at the June 25th to 2020 hearing. The point is that, and as we argued at that hearing, there are many ways of constructing a settlement. For example, the settlement funds can be paid by the defendant's purchasing annuity, and therefore the plaintiff is not, in that case, is not, in an appellee here, is not directly getting the funds. They're flowing through an annuity that the defense purchases, and therefore obviating the impoundment of any funds that would be utilized that would be necessary to satisfy a charging.
As a non-party to the settlement, you believe that you have the right to tell the parties how to structure it?
What we are arguing, and as the Florida Supreme Court held in the Miller versus Scobie case that's cited in our brief, a charging lien confers standing on the Ambler Law Group.
Excuse me, that was cited in your reply brief, correct?
A charging lien.
That you didn't argue that in your initial brief. That's something you didn't raise until your reply brief.
I think no, Scobie was cited in the initial brief. No. Scobie was
because I don't recall anything in the initial brief that asserted why you had a right to tell the parties how to structure their settlement.
Actually, it was Littman. Scobie is cited within Littman versus Fine that the charging lien confers standing to intervene in your own name as an interested party. So we were an interested party at the time we filed.
Did you intervene?
No, it's conferred by operation of law upon the filing of the notice of the charging lien in the pending action. And we filed the motion for enforcement of the charging lien prior to the hearing on the motion to approve the third settlement.
And is there anything that has occurred that will prevent you from enforcing your charging lien? We don't know. Because of the denial of due process, we don't know if the full extent of the amount needed to protect the charging lien has been reserved by the court, because we had no participation in that hearing to know what those terms were or to lodge in a meaningful way what the particular amounts were and how they were being structured in a manner that would have offered an adequate protection. As Mr. Lilly had argued, there were approximately 5,000 hours that were the sum total comprising the charging lien, which could consist of anywhere. Well, that's another thing you've glossed over, is the fact that I think the trial court determined that that provision in your retainer agreement was unenforceable.
Well, we did
seek the penalty provision.
So we did seek an interlocutory appeal, and that we were told it's a non-final order, and that still is an open issue and can be revisited. And we intend to have that revisited by the trial court based on the affidavit of Tim Chinaris, who said that there is no violation. But irrespective of that, the case of Shadris versus Yankakis at 668 Southern 2nd 186, the Florida Supreme Court from 1995 said that a quantum merit lien can be determined even if you have a non-compliant agreement, and the attorney is still entitled to the reasonable value of his service.
And I keep coming back to the same point. I sound like a broken record. I don't see anything that's occurred that will prevent you from enforcing your charging lien.
The question is,
your concern is whether there's going to be enough money to satisfy it.
My concern
that's a different issue than whether or not you have the ability to try to enforce it. And I don't see anything that's an impediment to that. I think that the issue is casted differently in whether our vested property right has been diminished or diluted by the fact that the only thing that the charging lien attaches to are the funds that are essentially frozen and put aside until there has been a full and fair determination and adjudication of what the charging lien amount is. In this case,
Have you cited any authority for the proposition that a party with a charging lien has the ability to have settlement funds frozen until their lien is determined, that you have the right to do that?
That is the nature of what the charging lien is, as opposed to a separate cause of action for example, breach of contract or quantum merit. The essence of what this court has held.
It would have been helpful to see some case law for this proposition.
For that proposition, we've cited case law that articulates the standard for what a charging lien is, as stated by the Florida Supreme Court and this court as well. And there was a case of Morgan and Morgan that was cited in the briefs that is, that went to that point as well. But I thought we'd cited a number of cases that articulate the proposition that the charging lien impresses upon the funds. In fact, there was the case that was cited in the materials here, that there is a vested right to an equitable hold on the settlement proceeds. And that was cited in the brief. I can get the court to that citation.
As you are approaching the 14th minute, you may want to take the opportunity to look for that case during counsel's response and provide it during rebuttal.
I think I will take that as sage advice, and I'll take a moment to look that up while I defer my time and save it for rebuttal.
You still have, some time left. You reserved 5. We're only at 14. Well, about 14 and a half now. I just didn't want you to lose it while you were looking.
Okay. The charging lien gives the attorney an equitable ownership interest in the client's cause of action, and the client's property right in his or her own cause of action is only what remains after the transfer to the attorney of the attorney's agreed on share. The citations for that are on page 11 of the reply brief.
Your argument is a violation of due process, not specifically targeting the amount of money that's being held. And so how are you denied due process? You weren't included in the original hearing, which I understand, but right. You did file a motion for reconsideration. There was a hearing on that.
We still were required to argue in a vacuum. We had our blinders on because we still were not privy to knowing and to tender meaningful arguments about what was the terms of the settlement that was being approved and how those funds were being directed. For example, if they were being directed by a defense purchased annuity, they would be essentially depriving the plaintiff of those funds if they were going to be needed to be able to satisfy the totality of the charging lien, which has not yet been determined. So the due process violation.
Stop about there, since we're way past 15 now. I want to keep your 5 minutes left.
I'm sorry, I didn't.
No. Is the answer complete? I don't want to cut you off short, but I don't want you, because I had promised to let you know. That's all.
I appreciate your letting me know. I'll go ahead and reserve my time, and if there's any further elaboration needed in response to Judge Rothstein-Yoakum's question, I will address it then.
Let me stop this clock. Okay. Mr. Ruiz-Caras, you may respond.
Good morning, may it please the court. I'd like to start specifically with what is in the record, because there was some argument there by Mr. Ambler about a motion to enforce filed in 2020. That is not in the record on appeal before you, which is limited to the appendices that were in the briefs. What is in the record before you is only 2 operative documents. The first is the charging lien itself, which was filed in November of 2017, and that's in the appendix starting at page 35. And if you look at the notice of charging lien, it indicates that it is pursuant to the engagement agreement. There's no mention of quantum merit, there's no mention of amounts. The second operative document is the verified motion to enforce the lien, which is at the appendix starting at page 117. And if you look at page 118 and 119 of this verified motion, which Mr. Ambler swore to under penalty of perjury, he asserts that his claim is based on a provision of the engagement agreement, the contingency fee contract, that if the file is transferred or withdrawn from the attorney by the client, it is agreed that the attorney shall have a vested interest and based upon hourly compensation for all work performed, and it sets an hourly rate at $450 an hour. There is no mention of quantum merit anywhere within the verified motion. At paragraph 10.
Is it necessary that quantum merit be in the motion when it seems that from the Supreme Court's decisional law, when the trial court held that his contract was not enforceable, quantum merit stepped in as an equitable remedy to allow him on a totality of circumstances to either A, establish that he has a charge lien, and B, if so, then to seek an amount. Would that not be the correct process?
It is correct that as a principle of law, if the legal remedy fails, here the law provides an equitable remedy, which is quantum merit, but it nonetheless has to be pled. You can't have an unpled. All I'm pointing out to the court is that on the record before it, there is no quantum merit that has been pled by the law firm here. In paragraph 10, I would like to point out paragraph 10 of the verified motion, this is under oath at page 121. There is a statement that $1.3 million held in trust would be sufficient funds to cover the attorney's fees and costs under the charging lien. So there is, in fact, the only sworn proof before the trial court as to the amount that would be sufficient to cover Mr. Ambler's charging lien is $1.3 million, and that is at appendix 121. So regardless of what statements might have been made later after the fact, which, by the way, we're talking about this filing was done in 2018, and in the interim, the record on appeal indicates that there's no billing records, no other sworn proof, no attempt whatsoever to try to verify the amounts of the billing or to assert any other type of claim. And what's significant, of course, is that that motion, that verified motion to enforce the lien, which is in May of 2018, the trial court determined that the contract was an unenforceable penalty provision violating the rules that govern our profession in August of 2018. And in that entire period of time, the record is devoid of any efforts to establish what the bills actually were, to make any effort to plead quantum merit. And I point that out because when we look at evaluating what the trial court did, this essentially is a due process claim by Mr. Ambler claiming that he did not have his due process rights because he didn't have an opportunity to present an objection to the court in June, in this June 25th hearing. Now, the record actually reveals that he had the opportunity and did file 2 objections to the motion to approve the settlement. The trial court considered the objections and indicated that it considered the written objections. Then when he complained further, because he was concerned about jurisdiction, he filed a motion for rehearing that was heard within days. And so the trial court gave a meaningful opportunity to be heard with respect to the issues that were raised here. The objections that were filed on June 23rd and the supplement filed on June 25th, which are the appendix at 156 and 163, show that Mr. Ambler was given a meaningful opportunity to present his objections. The court, in its order at 250, in the transcript at 254, considered the written submissions. And there were only 2 requests that Mr. Ambler made, or Mr. Ambler's counsel made, at the hearing on the motion for reconsideration. The first is that the trial court retained jurisdiction, and the trial court made it clear that it was retaining jurisdiction. And Judge Kelly, to your point, there is absolutely nothing in the record that would prohibit Mr. Ambler from being able to litigate his lien. His concern is about the amount that's being held, and that's what was iterated at the motion for rehearing or reconsideration in his counsel's second request, which was that an additional $1.3 million be set aside. The trial court considered that and considered the sworn proof that was before him, which is only that verified motion that Mr. Ambler filed in 2018, and made a determination after asking counsel to verify precisely how much was in their trust account. And there was $1,500,000 and change in the trust account, which exceeds the $1.3 million of which there was sworn proof. So the court determined, without determining the actual charging lien, determined that there appeared to be ample security. That type of a factual determination is, of course, supported by competent substantial evidence. It's the only sworn proof that there was before the court. The other issue, I guess, we should discuss, since this is all framed as a due process claim, it's important to recall what the standard of review is on a due process claim. The cases that were cited in the initial brief by Mr. Ambler are Second District Court of Appeals decisions. Henderson versus Lyons and Douglas versus Johnson. Judge Kazam wrote both opinions. And another one of the cases that was cited by Mr. Ambler, which was Carmona versus Walmart Stores East, which is also from this court in 2011. And although Judge Kazam wrote that one as well, Judge Kelly, you and Judge Casanueva were also on that panel. And you all determined that the appropriate standard of review is abuse of discretion on a due process challenge for a failure to have an opportunity to be heard. So the question is whether or not the trial court abused its discretion in what Mr. Ambler's asserting, not having an opportunity to assert its objection. There's absolutely no case law that supports the concept that Mr. Ambler is entitled to appear at this motion to determine the settlement. It was not resolving his charging lien, and he was given an opportunity to present his objections without disturbing the confidentiality of the proceedings by filing his written submissions. What's more, it actually appears from the record, and this was what the judge recalled, and it's undisputed in the record, and this is at Appendix 254 on the hearing transcript, that originally the hearing that Mr. Ambler is complaining about not being allowed to attend was scheduled to be heard in chambers. This is during, I guess, the midst of the pandemic. And it was moved, in courtroom, and then it was moved into chambers. And at that time, a phone number was disseminated. And Mr. Ambler actually called into the judge's private line for the hearing. And he was told that he was there as a party and to have his attorney, to pass the phone number on to his attorney. And apparently he didn't do that. There's no indication of what occurred, but the judge recalls Mr. Ambler being present at the hearing, but as a party without an attorney at 254 of the record. So there's even a hint there in the record that there was notice that the hearing was going on. And of course, he had the opportunity to submit his written objections. They were considered by the court, and the court dealt with his concerns and affirmed both that it's retaining jurisdiction and that there's sufficient security being held in trust to preserve whatever charging lien he might assert with respect to what there was already sworn proof as to how much the charging lien was.
Counsel, if I could go back to your last comment about
Yes.
that, there was a sufficient amount being held. I would like to borrow Mr. Ambler's statement about the cart before the horse, and I beg your indulgence, see if I can phrase this as an articulate question for a change, so that maybe Mr. Ambler can respond as well. As I look at Judge Day's order on enforceability of fee contract, my eye was focused on paragraph 2. And after vacating the order, it says, if so, whether the Ambler Law Group is entitled to any recovery in quantum merit. Is there a difference between a theoretical entitlement and an established entitlement? To see if I can give some structure to my concern is because there has been no hearing to determine A, entitlement, and B, the amount of the lien. Is there any due process right that has accrued other than a theoretical one that says, assume I prevail and assume an amount's given and assume that it's less than the amount? And my concern is with the word, and if I'm using it correctly, assume, because as I look at that, Judge Day is saying, I haven't yet determined whether or not his claim of lien is valid. And then I would have to do that first in order to decide what is the reasonable amount in quantum merit, assuming that we get there, and then consider the totality of circumstances, and then determine the benefit to the client and all those things. And so my concern is, as I'm looking at due process, usually you're saying you have some sort of right. And I'm wondering if to have the right, there needs to be an assertion by the court of a legal entitlement and a legally determined amount.
Well, your question raises more questions than I may even have answers.
And that's a
Because it
good
doesn't
thing
have-
that I'm sitting where I sit, because I get to ask them. And only later will I have to necessarily answer them. But I wanted to give each council a chance to say whether I'm going down the wrong stream of jurisprudence, a right stream, or it's not ready, it's whatever they are. But, I kept looking at that, and I'm looking at due process and an entitlement to hearing, and what right has yet been established. There seems to arguably, if I'm Judge Day, a bare claim of a lien.
And
That may be sufficient for our purposes.
You're correct that there has yet to be an establishment to the entitlement of a lien, right? And the determination, the assertion that was made in the pleadings before Judge Day were based on the contract, there was a determination that the contract was void and unenforceable. But there's still the potential, although it's unpled at the time, for there to be an equitable remedy of quantum merit. The issue is from a let's be as protective as possible of the potential for a property right. This is really a contingent, unliquidated, unestablished right at best, right? Because it may well be that it fails. If the contract fails, there's all kinds of factors that have to be determined to determine whether or not quantum merit is appropriate and what the amount of quantum merit is. But be that as it may, even if that right is not ever going to be established, the court here had before it sworn proof as to what the outermost limit of what that lien could be. Because balancing the interests here, the court also has an incredibly injured individual who's the plaintiff, and these are funds for his care and treatment that are necessary for his care and treatment. And he's trying to balance, well, some funds have to be dispersed for this versus this lien that's been asserted. And the only sworn proof that's before the court is the outermost limit, that ceiling is $1.3 million. So he's not making any determination as to the validity of the lien, how much the lien might ultimately be. Ultimately, there may be no lien. It may be a zero, or ultimately maybe $100,000 that the court makes that determination. But what he had before him when he made a determination here with respect to the settlement was there's sworn proof that the outermost limit is $1.3 million. So to the extent
and quantum merit, even if he does have an argument for quantum merit, that's still limited by the maximum amount provided for by the contract, right? And so if the only evidence before the court is that based on our prior hours and the amount we charge per hour, it will be this much. I mean, that's what you're saying, right? I just want to make sure. Okay.
Exactly. And frankly, that's all that's been asserted by Mr. Ambler in the pleadings that were before the trial court were use this hourly calculation and here's how many hours I have. What he asserted was less than the $1.3 million, to be sure. He actually laid out some sort of preliminary calculation for hours in that same verified motion, but then said to be safe, let's make it $1.3 million that's held in trust. So that's where that number is coming from. So that's what in the court. Sorry.
In the motion,
Even assuming A, B, and C, this is the worst that could happen, even if he meets all his ducks in a row, so to speak.
Exactly. And so without deciding it, that's why he was, and that goes to the question of there's nothing that's preventing Mr. Ambler from litigating his lien, which was Judge Kelly's point.
two things I wanted to ask you. In the motion for consideration, I think that's where he raised the issue of actually our lien is going to be around 3 million or so. That wasn't verified, was it?
It was not verified.
Okay, let me wait. Second part of that question is, had they appeared at the hearing to approve the settlement, would they have had the ability to introduce sworn testimony as to what they thought the amount of their lien was going to be to increase the amount over the previous amount they had attested to?
No, nor have they made any arguments to that end.
No, I know. I'm trying to understand what they lost by not being at this hearing. So
Yeah,
I'm
nor frankly,
guessing.
you know, even at the motion for reconsideration. So you're wondering, well, here they file a supplement and they're trying to object to the confidential settlement. And yet even then there's still no sworn proof, no affidavit, nothing that says this is the amount. Even in that,
They just threw a
supplement to their
number
motion,
out based on a theory that the trial court had already rejected.
They threw three numbers. They said somewhere between 2 to 3 million. And then they said, but just give us an additional 1.3. And then that's what At the motion for reconsideration at the hearing, Mr. Lilly argued, please just give us an extra 1.3 in trust. Yeah, without any proof or basis for it. So just summing back up again, under the abuse of discretion standard, Mr. Ambler had an opportunity to be heard. His arguments were presented, and the court has retained jurisdiction. There is no impediment to his ability to litigate his lien, and the court, on the sworn proof before it, relied on competent substantial evidence in determining that there was ample security there for this as yet to be determined lien, without adjudicating whether or not there even is an actually valid claim here for quantum merit. Unless there's any further questions, thank you all. We'd ask that you affirm.
Thank you.
Thank you for allowing me to use my technological skills and stopping time from running. And now we can start with rebuttal. With a clear slate, you have your 5.
Thank you very much. Thank you very much, Your Honor and judges. Let me address a couple of things. First of all, a couple of misstatements. At the hearing that the court held, I actually dialed in on the judge's private line, and the transcript reflects that I told the judge that I have my counsel and a court reporter on the line, on another line that we were, public line that we're told to call in, and I was told to hang up, and that they were not, and I was not allowed to be participating in that hearing. So I just want to be clear, that's what the transcript shows on that point. To Mr. Ruiz's comment about the quantum merit, the Shadris versus Yankakis case, which I cited earlier, which was the Florida Supreme Court case from 1995, addresses the idea that quantum merit would apply as an equitable remedy, even if you have a non-compliant agreement and the attorney is still entitled under the authority of that case to a reasonable value of their services. So it is still an open question as to whether that was a non-compliant agreement or not, but right now, taken as the record is, it is considered one, and so the Ambler Law Group is entitled to a quantum merit recovery under the authority of Shadris. The important thing is that our jurisprudence and the second DCA has held clearly that a charge is vested by the notice that is given, proper and timely notice that is given by a party of the assertion of the charging lien. That occurred on November 15th of 2017. The verified motion was filed in May of 2018. The hearing that we're complaining about was 2 years later in 2020.
Mr. Ambler, do you disagree that quantum merit would be limited to, I mean, it's still limited by the terms of the contract, correct?
That's hard to say. If the contract is void, as Judge Day found, then I don't know that you are limited by the contract. You're limited to the principles of quantum merit. I think that's an unsettled question of law, but even assuming that you are limited to the terms of the contract, there's been no determination that the amount of recovery under the contract collectively for the 3 settlements is going to be sufficient.
Well, and that's what I'm wondering, because you're relying on the 3 settlements, but pursuant to the terms of your contract, if you were, if the plaintiff selected different counsel during the proceedings, per your contract, you were still entitled to the reasonable value of the services that you had already provided. So basically, my understanding of your contract, it would transform it from a contingency to a straight up calculation of hours and hourly rate. Is that not correct?
That is not quite correct under the Florida Supreme Court case of Shearsea et al. Versus
I'm just talking about the terms of your contract.
Right. But the lien, but the issue is under a valid charging lien, it's determined by the totality of the circumstances for quantum merit, not just based on a lodestar. So if the contract has both contingency and lodestar elements to it, and it was a hybrid contract for both non-contingency work that was done for non-contingency related issues dealing with non-malpractice things like retirement benefits and guardianship matters and stuff, as well as contingency matters. But at this point, given the status of the record, it's just an open question still. It's an open question that's determined by quantum merit, but it is not a question, as Judge Casanova was trying to get to in his earlier question to police counsel, that it's not an esoteric argument of whether there's entitlement or not, the charging lien becomes a vested right upon timely proper notice to the opposing side and to the court, which occurred. And then there was a verified motion early on in 2018 that was trying to preserve an amount relative to the second settlement. There was a big footnote that's been missed here on page 120 of the appendix, where it talks about these were preliminary calculations that were made. It discusses that issue in great detail. And to roll forward 2 years later, at the time that we had not yet had an evidentiary hearing on the charging lien, it was pointed out at the motion for rehearing that the calculations were at about 5,000 hours, which was higher than the amount 2 years earlier. And the explanation for that is in there. And there's no requirement for those hourly rates to be predetermined and to operate as a ceiling. The quantum merit, again, based on totality of the circumstances, is not just a lodestar. It is the totality of your contribution to the ultimate outcome in the case. All of those things would be determined at an evidentiary hearing, a hearing that we have not had yet, and therefore determining the propriety of distributing funds, any funds to the plaintiff, which by releasing those funds diminishes the value of protected funds that the Ambler Law Group would have a potential claim to, is the heart of the due process violation. It's not.
So you were trying to
let Judge Rothstein Yocum ask a final question, since we have passed through the time barrier. And before she asks a question, I will let you know that I noticed in Judge Day's order there was nothing invalidating the lien. I was waiting to see if anybody brought that up, and I will be sure to share that with Judge Casanova. Judge Rothstein Yocum.
It just seems to me that you were trying to turn what you're saying is you were not permitted to turn the hearing on the third settlement agreement basically into a hearing on what you think is an appropriate amount to be held in the law firm's trust account. And what I'm wondering is whether you had an obligation while any of this was ongoing to bring to the court's attention before that what was in the trust account was not going to be sufficient to cover your reasonable expenses.
Well, short answer to your question, we attempted to make that known to the court before the hearing on June 25th that it was not adequate, the best we could, but we were doing so in a vacuum. We weren't required at that point because we hadn't completed discovery that the court had ordered, and that's a whole separate issue, but discovery had not been completed on the issue of the charging lien, the information we were trying to obtain to be able to close that door and pin all those numbers down. So we were arguing from the facts that we had at that time that the court needed to impress upon all of the funds that were there and proceed with the determination of the charge lien at the evidentiary hearing rather than going ahead and approving any disbursements. You can approve the settlement, but not approve disbursements from the settlement pending the resolution of the charging lien. That's where we were denied our meaningful opportunity to be heard. And that's what this court in the Carmona versus Walmart case in 2011 said, that due process requires not just the notice, but the full and fair opportunity to be heard at that hearing. And we couldn't lodge any objections when we didn't know the nature of what the terms and conditions of the settlement were in order to fashion and articulate our objections at that hearing.
Okay.
And for those reasons, we asked the court reverse the order of the court of June 26th and either withhold disbursement of the third settlement funds or order that they be disgorged and held in the registry of the court or in the trust account of the appellee's counsel pending a final determination of the charging lien. Thank you for your time.
Thank you, counsel. It's been an interesting discussion today. I thank you for your indulgence, in helping us along with some of the various issues that permeated around this case. I appreciate it very much, and I'm sure the panel does as well. We wish you safe travels and good health, and I will let you transfer back wherever it is in cyberspace. We will bring over the second case, which is Austin Portable Storage and Pods Enterprises. Okay, one.
Good morning, Your Honors.
Good morning. I'm waiting for the other camera. There, we found counsel. That's good. The ceiling was nice, but I didn't think that's what we were going to watch the whole oral argument here.
I was hoping for that.
Me too. Okay. All righty. Mr. Radchek, I believe you represent the appellant in this case. Is that correct?
I do, Your Honor.
And would you like to reserve any time for rebuttal?
Yes, sir. If I could reserve 5 minutes, that would be great. And I am trying to get this camera to focus a little bit better there. There we go.
Okay. You look like you're in focus. Time now, you may start.
Thank you, Your Honor. May it please the court. Although the trial court judge below, Judge Scott Stevens, ruled in favor of PODS, he did so solely because he said that there was no Florida court that had yet ruled on the legal issue that we're addressing now today. But he embraced the legal issue that we're dealing with and the arguments and theory supporting my client's claims. In fact, Judge Stevens—
The theory is breach of contract, right?
The theory is twofold. One, that there is a breach of contract, and two, that there is a breach of the covenant of good faith and fair dealing.
Well, but that doesn't stand alone, right?
No, ma'am, it does not. We recognize—
Okay,
that—
so let's get right to it. What is the contractual provision that you believe was breached?
Okay.
And how was it breached?
There are two provisions in the agreement that stand on this. The first is section 2.2 of the franchise agreement, and the second is section 2.4 of the franchise agreement. Section 2.2 confers upon the franchisees the exclusive right to operate their franchise business within their exclusive protected areas. As part of that right to operate the business is the exclusive right to use the trademarks in their restricted areas. Section 2.4 of the agreement specifically provides that PODS does not have the right to grant anyone else, including PODS, but any other person, the right to use the marks within those protected areas. Under the law, as Judge Stevens recognized, should probably be applied here, but needs this court to determine it. The case of original appellation in the first instance, and then the case of Chroma in the second instance.
Let me just stop you. Can you describe for me what the breach of contract was, please? You
Sure.
specified the provisions.
Yes, specifically section 2.2 says that in their contract, as I said, the franchisees have the right, the exclusive right, to operate their franchise business within their protected areas. Section 2.2 specifically also says that with that right comes the exclusive right to use the marks within their territories. Section 2.4 of the agreement specifically says and prohibits PODS from doing anything that grants the right to any other person to operate.
So how did PODS breach that contract?
What PODS did under the original appellation and Chroma cases is it granted to U-Haul a license to use the marks within those territories.
I thought it sued U-Haul and it got a permanent injunction that enjoined U-Haul from using the marks.
It did, and that's prospective harm. But what PODS also did was it not only sued for the injunction, but it sued and then importantly settled with PODS for $41 million based upon damages that not only PODS but the franchisees sustained. And under those—
Doesn't that go to the like Chroma and the good faith and fair dealing, the implied obligation?
It goes to both, Your Honor, because under both cases, and then looking back to the McClintock case, what PODS did when it settled with U-Haul and or went to court and took money from U-Haul was it effectively conveyed a license to U-Haul for the use of.
I don't understand that. I do not understand that. You're going to have to try to explain that to me. I'm sorry.
Okay, well, the case of Chroma, again, original appellation relying upon McClintock and then Chroma as well, says if you pods effectively want to go out and take money from an infringer, you are condoning, you're allowing, if you will, that person to use the marks, and the use of those marks constitutes a breach of the agreement. It is both, I think, a legal recognition of the fact that you are conveying the court in original appellation called it an involuntary license, relying upon McClintock, but effectively you're going out and you're saying, here, you pay us for the use of this mark.
No, but they didn't allow them to use it. They got an injunction to prohibit them from using it.
But that's going forward, Your Honor. That's not addressing.
Well, they had to sue in order to get the injunction. They never at any time that I noticed in this record said, oh, U-Haul, it's okay. They sued them.
They did sue them and then, of course, settled with them, but they didn't just sue them to stop the use. They
got damages as well, and for corrective advertising, and then they got disgorgement of profits.
Correct, Your Honor. And what they really did was they said, okay, we'll take care of the injunction is nice and it's important and it's great. We'll get to that on the issue of whether or not that satisfied the covenant of good faith and fair dealing going forward. But what it did was it said, okay, you infringed, you used our marks. Now pay us for it.
So you're saying they effectively granted a temporary license, is what you're saying?
Effectively a retroactive license. That's exactly what the court says. It says.
Well, wait. Let me make sure I understand the elements of the award. Part of it was for corrective advertising.
Yes, ma'am.
Correct. Okay. And then the rest was disgorgement of profits, which was the wrongfully earned profits by U-Haul. And disgorgement was the measure of damages because pods, it didn't really have the ability to prove what it lost as a measure of damages. So instead, the award was measured by the wrongful gain of U-Haul. Now, were there any other elements of damage?
No, Your Honor, that's a recognized, effectively a substitute measure of damage.
Right, when you can't prove.
Right, when
what you lost.
It's hard to prove a sale that didn't occur.
Right. Now I understand what disgorgement is.
Right, but all of the evidence that was presented by pods at the trial was predicated upon the fact that pods and the franchisees lost sales to U-Haul, and in fact, that was specifically in their complaint. They specifically pledged.
But they weren't awarded damages for that, were they?
They were. That's exactly what the damages were.
I thought you said the damages were disgorgement.
Yes, the damages that were awarded were disgorgement, but it was predicated upon the fact that U-Haul made sales at the expense of pods and the franchisees. They would not have made those sales or those profits had they not infringed and harmed pods and the franchisees by taking their sales. In fact, in the complaint, they alleged that U-Haul engaged in a systematic plan to steal business sales from pods and the franchisees. And then pods at the trial put on evidence, testimony of experts, witnesses, executives of pods that all went to the fact, and the franchisees themselves, that all went to the fact that they lost sales, they lost business to U-Haul, and that hence the disgorgement was appropriate to compensate pods and the franchisees for their damages.
But that was not straight up loss of sales. That was evidence presented to show dilution of the mark, wasn't it?
No, Your Honor. And in fact, that's sort of this great myth that PODS keeps putting on now in this case, that they never introduced at the underlying trial. And in fact, in this case, and we cite to it in our briefing, the CFO of PODS specifically testified that there was no diminution in the value of the marks or the brands, that they never focused on that in the PODS case below. They never valued it. They never analyzed any impact on the PODS brand or marks, and that they've never adjusted the valuation of the brands or the marks as a result of PODS activity. So while we've heard a lot about that in this case, it didn't exist in the underlying trial. And that's one of the great myths that they are putting forth to this court in an attempt to avoid what they really did in the trial court below. Now, you've also asked Judge Kelly about whether or not part of the damages that were awarded were for the corrective advertising. Let's bear in mind that the advertising has been paid for by the franchisees, right? So in order to compensate the franchisees for their injury suffered as a result of the misconduct, you have to compensate them by allocating to them part of that corrective advertisement. Had PODS in fact used the money that it took from U-Haul, supposedly for corrective advertisement, which even Judge Stevens recognized they never did, and he alluded to it as a windfall, then they would have properly shared it, but they never used it to either discount, reduce, offset any of the charges that PODS franchisees paid for advertising or historically paid. In fact, the evidence in the record shows that after they got the $41.4 million, they increased the amount that the franchisees had to pay for advertising and didn't use any of the money that PODS recovered from U-Haul for advertising purposes. There's undisputed evidence in the record for all of this. And so what happened is PODS took $41.4 million and put it into its general operating account, even though it recognizes specifically that PODS franchisees were hurt by U-Haul's conduct. And PODS, as you said before, effectively granted, whether you call it a temporary or perhaps retroactive license for the use of the marks, it breached the contract specifically under the original appellation, the McClintock before that, and then the Chroma case in the Florida Middle District, which applied Florida law.
But go on, Judge Kelly.
No, you go.
None of those cases involved a retroactive or a temporary license.
They all did. That's exactly what original appellation talked about.
No, original appellation said, you pay us off and we promise we're not going to sue you and we're not going to let our franchisees sue you.
Yeah, they said that to settle the damages historically, right? And there's something that PODS has said in their briefing, that they said that they sold out the franchisees and didn't obtain an injunction. There's nothing in the record that discusses an injunction one way or another. It said, we won't sue you, but it also presumably said, because you're not going to infringe anymore. There's an agreement not to infringe as part of this settlement agreement. Now, if the defendant there, if TOPS went ahead and infringed again, I'm sure that they would have sued for it. So it was a settlement agreement to prevent future infringement, but it was a payment all for historical retroactive damages that even the court recognized that if the licensee could prove that it suffered damages as a result of it, it would be entitled to share. Now, If I might, let me go on to the issue of the covenant of good faith and fair dealing, unless the court has any further questions on the breach of contract.
FYI, you are at 14.
Okay, I'll do it very quickly and I'll reserve part of it. The cases all talk about the covenant of good faith and fair dealing, and they talk about it equitably. Judge Stevens, I'm sorry, unfortunately went a little bit astray when he then ruled that the injunction was sufficient to take care of the covenant of good faith and fair dealing. Again, that only goes on a prospective basis, not retroactively. But he also cited the cases of Seppi and Chalfanti, which talk about a situation where the covenant applies to all contracts, but those cases, and also the cases that PODS relies upon, talk about whether when the licensor has the right, or I'm sorry, the power, but not the obligation to act. And we don't have that here. We don't have a situation as to whether or not the injunction was good enough because PODS only exercised the power to the extent that it wanted to, i.e. the injunction. That would be a hypothetical that doesn't exist here. Here we have very specifically PODS seeking monetary damages in the first instance. If PODS didn't want to seek monetary damages, i.e. convey the license to U-Haul, it didn't have to. Or hypothetically, it may not have had to. We can address that when and if that issue ever comes up. But here they exercise the power that they had to get money from U-Haul. So that takes it out of the context of Seppi, Chalfanti, the Murella case that PODS cites, or the Jeffries leveraged credit products case that they cite, in which case they talk about a situation where you don't have to do more than you're obligated to do. But here we have PODS who did do more than it says it was obligated to do. And as a result of having done that, it breached its covenant of good faith when it refused to share the settlement proceeds based upon the license that it conferred. I recognize.
While we're on this point, may I ask a question? I'd like you to clarify something for me.
Please.
SEPI in those cases deal with an implied covenant of good faith and fair dealing.
Yes, sir.
The attachment to this pleadings, and I was looking at it, paragraph 20.1 has a written express provision for good faith. Are we going on an implied theory, or is this the correct contract that was being used in this case, and was it changed by the addendum?
No, nothing was changed by the addendum, Your Honor, and so
20.1 has an express covenant it says the parties expressly agree that this agreement contains an express covenant of goodwill and fair dealing. So are we dealing with an express or an implied or both covenant?
Both covenants, Your Honor.
So express and implied?
Yes, sir.
Okay.
Yes.
Thank you. I just wanted to be sure that I hadn't misread that contract and that it was pertinent to our legal analysis.
It is, Your Honor, and thank you very much. I'll reserve the rest of my time unless there are any other questions.
Thank you.
Good morning, Your Honors. May it please the court, Jeffrey Buckholz.
One second. I'm unfortunately a timekeeper and I'm trying to multitask. No, that's not your fault. Write down my notes so I don't lose a thought and then clear the button so you don't start off with his time counting against you. We are good, counsel. Please go ahead. Thank you.
Thank you, Your Honors. Good morning. May it please the court, Jeffrey Buckholz for PODS. I'd like to start with the question that Judge Kelly started with. This is a breach of contract case, and yes, there's also a claim for breach of the implied covenant, but as Judge Kelly pointed out, that claim doesn't stand alone, and therefore, really, this is just a breach of contract case. So the theory, there has to be a theory for some provision of the contract that we breached and how we breached it. And I think what we've just heard is that theory is that PODS granted U-Haul a license by suing U-Haul, getting an injunction against U-Haul and collecting damages for U-Haul from infringement. And that just doesn't make any sense. It doesn't make any sense to say, either in reality or in law, that that somehow conveys a license to U-Haul in exchange for money. And if Your Honors, I'm sure, have seen in the franchisees' briefs, there are multiple places where they resort to phrasing like pods allowed U-Haul to infringe in exchange for money. And Your Honors, that's just not what happened. Pods did everything it could to stop U-Haul from infringing and got an injunction. And unlike an original appellation, where the licensor initially won a motion for an injunction and then gave up the injunction, didn't pursue that further, and instead got money, when we settled with U-Haul, we preserved the permanent injunction in perpetuity, in addition to getting the $41 million in settlement. So we did protect the interests of the franchisees by getting that injunction and preserving that injunction in the settlement, beyond anything that the duty of good faith could have required us to do, given the language of this contract. And I want to come back to the language of this contract, because it's a contract case, and the language of this contract is what governs, not the language of some contract that issue in another case. We heard a lot about McClintock just now. And McClintock is a great example of a contract that's very different from this contract. In McClintock, the contract said that the licensee had the right to 50% of the proceeds of the sale or other disposition of the rights at issue, of the work at issue, excuse me. So of course, where there was another disposition through litigation of the rights at issue, the contract said the licensee got 50% of those proceeds. Well, here, far from anything like that, the contract says in section 5.1, this is page 1829 and 1893 of the record. Actually, let me just say parenthetically there, it's a little bit confusing because the original contract is first at 1829, and then there's an addendum that changes some terms. It doesn't change any of the terms relevant here. None of the contractual language that I'm going to quote to Your Honors was changed in the addendum. So whether the court looks at the 1829 or the 1893 site, it's the same language. The language is, this is 5.1. It says, you, the franchisee, acknowledge that we pods own the marks. Your right to use the marks is derived solely from this agreement and is limited to conducting the franchise business pursuant to this agreement. This agreement does not confer on you any goodwill or other interest in the marks, and your use of the marks and any goodwill established thereby inures to our exclusive benefit. So here the contract says in black and white, the agreement does not confer on you, on the franchisee, any goodwill or other interest in the marks. Well, the franchisee's complaint in their breach of contract claim says that they have an equitable interest in the marks, and they rely on a case like McClintock where the court said that the licensee was a part owner of the work because of the way the contract was phrased. Well, there's just no way to say that here, given the language of this contract between these parties. They have no interest in the marks. So how do they get from no interest in the marks and all of the other contractual language to the same effect to this idea that they somehow have a right to share in the proceeds of an infringement action?
Let me ask you, because I was wondering this reading original appellation, if the appellants are actually in the same position as Diamond was in that case. And it seems to me that the appellants are one step removed in that, using original appellation as the example, they are more like, say, a stationery store that was licensed to sell Cabbage Patch Kids merchandise, and in the context of making those sales could advertise, hey, we've got Cabbage Patch Kid merchandise. And would that be more akin to the role that the appellants are playing vis-a-vis pods, as opposed to Diamond's role, which was manufacturing the stickers and using the mark itself on the, using the trademarked imagery on the stickers? I mean, is it your position that they're not even in the same position, and so the case is not applicable for that reason?
Your Honor, I think the original appellation is not applicable for multiple reasons, some that you alluded to and other ones that I'll try to explain. So this is a franchise agreement. This isn't just an exclusive licensing contract like McClintock, or like even if original appellation could be thought of that way, where a licensee has the exclusive right over a work or what to do in a certain channel with a work. This is the exclusive right that these franchisees have is to operate the franchise business. And yes, they have the right to use the marks in connection with doing so, but it's not as if we gave them the exclusive right over our marks. I mean, the contract is in 3 different places says the contrary, that we have the right to retain all ownership of the marks and all discretion with respect to the marks and all goodwill inures to our benefit. And in 2.5 national accounts, we and other franchisees get to use the marks even in any other franchisee's exclusive territory. So in short, this is the franchise agreement context. It's quite different from the exclusive licensing context at issue in some of the cases they rely on. And I think it's important. I mean, so in other words, it's not an accident that this contract is worded differently from some of the contracts at issue in for example, McClintock, where it's a more traditional exclusive license arrangement. But the other important differences with original appellation are, number one, original appellation, as I said before, originally the licensor moved for and was granted a preliminary injunction to stop the infringement, and then decided they didn't want an injunction. After all, they wanted money in exchange for allowing the infringement. And I just heard Mr. Ratchik say that somehow the settlement agreement there that involved the payment of money to the licensor also prevented further infringement. And I'm sorry, Your Honors, the case doesn't say that. There's just no reference whatsoever in either of the original appellation opinions to that notion. And there's just no basis for that. So here, rather than foregoing an injunction that would have protected the franchisees in exchange for more money from U-Haul, we preserved in the settlement the permanent injunction against U-Haul and thereby protected the franchisees. The other important difference with original appellation is the 11th Circuit in original appellation repeatedly relied on the notion that the licensor had a fiduciary relationship requiring it to protect the licensee. Well, here in section 20.1 of the agreement, it says, neither this agreement nor the dealings of the parties pursuant to this agreement shall create any fiduciary relationship or any other relationship of trust or confidence between the parties. And the franchisees tried anyway to bring a claim for breach of fiduciary duty. Trial court dismissed it appropriately, and the franchisees haven't tried to appeal that dismissal. But really what they're trying to do in relying on original appellation is smuggle in this notion of a fiduciary duty anyway through the breach of contract claim, contrary to the explicit terms of this contract. So original appellation, properly understood, supports us, does not support the franchisees. And the same is true of Chroma, the other case that they rely heavily on. And McClintock I've already addressed, where McClintock actually exemplifies what a contract would look like that does give the licensee a right to share in the proceeds. And in Chroma, one important difference in Chroma is that the parties in Chroma appear to have agreed, this is from the 11th Circuit's decision, that there was an obligation by the licensor to indemnify the licensee for damages suffered by the licensee from the infringement. Well, there's no provision like that in this contract. And so, of course, if you have a contract that says that the franchisee, that the licensor owes money to the licensee if certain things happen, well, then if those things happen, the licensor owes the money. That's what the 11th Circuit said. That, there may have been a breach of contract claim there because of the terms of that contract that provided for an indemnification obligation. There's no claim like that here. There's no provision in this contract that would support it. And really, the language that the franchisees seize on from Chroma is from a decision denying a motion to dismiss. And it's not just that it's a preliminary. The trial court here was correct in saying can't rely too heavily on that at face value because it's just a preliminary decision denying a motion to dismiss, but it's more than that. It's the trial court in Chroma granting a motion to dismiss a promissory estoppel claim, which is what the licensee had brought, in the process saying you can't bring a promissory estoppel claim because there's a contract here, and where there's an actual contract, you can't rely on this kind of extra contract promissory estoppel notion. Well, then ironically, the trial court in Chroma goes on to say, maybe you can bring a contract claim relying on this notion of good faith and fair dealing. Well, as your honors know, Florida law is crystal clear that you can't do that through the good faith and fair dealing duty either, just like you can't through promissory estoppel. If there's a contract, the terms of the contract govern. A claim for breach of the duty of good faith and fair dealing isn't a standalone claim. It doesn't add anything to the contract. There has to be a provision of the contract that's breached, an actual provision of the contract. Here, there is none. So I just want to mention a couple of other provisions of the contract that reinforce the points that I've made. In addition to 5.1, which says the franchisees have no ownership interest in the marks and we retain all goodwill and all interest, 2.7 reinforces that. It's entitled Our Reservation of Rights. And it says, except as otherwise expressly provided in this agreement, we pods retain all of our rights and discretion with respect to the marks. So the question under 2.7 would be, is there something else in this agreement that expressly departs from that expressly gives the franchisees a right to share in the proceeds of infringement? There isn't. There just isn't. And that's why they have to concoct this notion, this contrived idea that somehow we granted U-Haul a license by suing U-Haul and preventing U-Haul from infringing. That just doesn't make any sense. It's contrary to reality. I want to briefly address points that were made about what happened in the U-Haul case and what the damages reflected. And Your Honors, the best evidence of what happened in the U-Haul case and what we recovered in the U-Haul verdict is the evidence from the U-Haul case itself, right? There's a full record that's in the record here from the U-Haul case. And what the franchisees are trying to rely on is depositions that they took years later, years after the U-Haul litigation was over, of some people who had testified or been involved in the U-Haul litigation, where Mr. Ratchick tried to get them to agree to some imprecise or tendentious characterizations of what happened. And sometimes they let those words get put in their mouths. But Your Honors, none of that matters. What matters is what actually happened in the U-Haul case. And if Your Honors look at the U-Haul case record itself, Your Honors will see that we did not present, a claim to the jury for lost profits damages. Yes, we said that we were harmed, including through losing sales by U-Haul's infringement. Yes, franchisees who testified said that they were harmed as well. There were a few anecdotes presented to the jury where customers would call and seem confused about whether U-Haul and pods were the same. And so, yes, there were anecdotes like that presented, and the U-Haul jury, hopefully believed that pods and the franchisees were injured by U-Haul's infringement. But that's very different from actually presenting a damages theory to the jury, where you're trying to prove and quantify your lost sales and your lost profits and recover damages measured by that. We didn't do that. So at page 36, 62, and 63 of this record, we have Walter Braddock, who is our damages expert in the U-Haul case, who tells the U-Haul jury, he admits on cross-examination, quote, "I did not quantify any lost sales or lost profits due to lost sales. I haven't quantified any lost profits or any lost sales in my analysis." That's crystal clear. Our other expert in the U-Haul case, Professor Russell Weiner, similarly at 1614 of the record, on cross-examination, again, admits to the jury in the U-Haul case. The question is, you don't know how much business, if any, pods has lost by virtue of U-Haul's use of the term pods, correct? And his answer is, what we've heard this week is we know they lost some business, but I don't know how much. That's correct. And that reference to what we've heard this week is the anecdotes I mentioned earlier, where people talked about certain instances of customers calling or prospective customers calling and seeming confused. And then maybe the best evidence of all, Your Honors, of what happened and didn't happen in the U-Haul case is the U-Haul court's order denying the post-trial motion. So if anyone knows whether we presented a lost profits case and recovered lost profits from the jury, it's the judge who presided over that case in that jury trial and who acted on the post-trial motions. That's in this record too. It starts at 1977, and at 1998 and 99 of that order, the judge addresses U-Haul's post-trial motion, arguing that we didn't prove harm as was required for us to collect damages. And the judge says, pods was required to present evidence that pods mark lost value to recover damages for corrective advertising. That is exactly what pods presented to the jury. Evidence that U-Haul's use of the marks damaged the pods brand. And so when Mr. Ratchick told Your Honors a few minutes ago that it's a myth, that's his word, a myth, that we presented evidence in the U-Haul case that our brand was damaged by U-Haul's infringement, Your Honors, that's just directly in the teeth of what the U-Haul court itself said happened in the U-Haul case. And so who are you going to believe? The U-Haul judge about what happened in the U-Haul case, or some argument made by lawyers that outside of the record in this case about what happened in the U-Haul case? I also want to just close by saying, if Your Honors have no further questions, that the argument about what happened in the U-Haul case and what the damages there reflect or don't reflect is a little bit beside the point, because again, this is a breach of contract case. And so unless the court is going to buy this notion that we somehow granted U-Haul a license by suing U-Haul and getting an injunction against them to prevent infringement, it doesn't really matter what the damages in the U-Haul case reflected. There's still no provision of this agreement that gives the franchisees a right to the marks or in proceeds of infringement of the marks, because that's just not what this contract says. So if Your Honors have no further questions, I'll cede the balance of my time. I know you have other cases this morning, and I'm happy to give some of my time back. Thank you, Your Honors. We'd ask the court to affirm.
Thank you, counsel. Let me clear the calculator here. Before you ask me, I will say you have 3 minutes remaining for rebuttal. I anticipated the question the answer doesn't invade your time.
Thank you, Your Honor. Let me address just a few things. First, to Mr. Buckholz's comments about who you're going to believe, the witnesses now or the witnesses then. Let's be very clear that in the testimonies given in this case, in almost every case, in almost every instance, we ask the witnesses not independent questions, but to affirm their testimony from the U-Haul case. And that's how the evidence was presented in this situation. And then Mr. Buchholz says, who do you want to believe? Does this court want to believe the 11th Circuit in the original Appalachian case and the Middle District of Florida in the Chroma case as to what constitutes the conveyance of a license of the marks? And I would submit to you that you should adhere to those rules because they are on all fours here. Now, again, focusing on the original Appalachian, we're not dealing with a situation where, and we're not contesting who owns the marks, who retained the interest to the goodwill in the marks. That's the same facts as existed in the original Appalachian. And they made it very clear that it had nothing to do with ownership of the marks or the goodwill. What they found, however, was there was both this actual as well as implied covenant in there that you shall do nothing to harm the value of the marks, and that as the licensor, and there's no doubt that they're a licensor of the marks, even Judge Stevens recognized that, and the cases in Florida recognize that as well, is that you shall do nothing that harms the interests of the licensees in the marks. But that's what PODS did here, both expressly by granting that retroactive license, as we've talked about, and then to keep all the money from them that was given to them. You know, this is
Mr. Ratchick,
yes.
What, in your view, the only way PODS could have escaped this sort of broad notion that if the franchisor gets money, the franchisees get their share of it too. The only thing that PODS could have done was not seek any monetary damages. All they could have done was sue for injunctive relief.
No, they could have, and again, we're talking about hypotheticals as to what might or might not be, but they didn't have to present evidence of the damages suffered by the franchisees. If they had collected damages unrelated to the rights and obligations of the franchisees, then we wouldn't be having this conversation.
So that was their breach. That was how they breached the covenant of good faith and fair dealing. That was how they harmed the interests of the licensees or the franchisees.
By doing both things, by giving away rights that directly impacted on the franchisees, and then two, by not sharing the damages that they sought and collected from U-Haul for the benefit of the franchisees. I mean, imagine this. If you go and sue somebody on my behalf for the injury to me, and then you keep that money, there's something wholly inequitable about that, especially when you promise me that you won't do that. You have an agreement with me that you will, one, protect my interests, and two, not give away my interest to somebody else pretending to do it on my behalf, but then keeping all of my money. And that's exactly what they did here. And to address the question that you asked earlier, Judge Rothstein-Jakob, about—
This will be, I think, safe to say your final response, since we're way past 3. I want you to answer the question if you would.
You asked the question whether or not we are more like a stationery store, and I'm not exactly sure that I followed that question. But no, we are a direct licensee, granted a license to use the marks by PODS specifically to operate our business. We not only have the right, but the obligation to use those marks in the conduct of our business. And if somebody like U-Haul comes in and uses those marks to our detriment, and we can prove that it was to our detriment, which the franchisees have done, then that constitutes more the relationship that I'm talking about than the idea of a stationary store that just has to sort of mention it. We are direct licensees. Having answered that question, Your Honors, we ask that the court either reverse outright or remand with instructions to enter summary judgment in favor of PODS and award the damages, which I haven't had a chance to talk to, but which are in the brief. It's approximately $5.6 million in favor of the franchisees.
Thank you. Thank you both. We wish you well and good health as well, and will allow you to transfer over into whatever cyberspace room you're going in. And if I had a Mr. Scott, I would ask him to beam you over, but I don't. So our wonderful staff will take care of you.
You've got to
in modern
stand in
times.
line for that one. So
Pardon me?
you have to stand in line for that one. Thank you, sir.
Absolutely. Thank you all. The next case coming over is Kalki. We have one counsel. Now we need our other counsel. Okay. We have everyone. One illuminated, and Mr. Maros, you are not quite totally in the dark, but it is dark screen behind you. We are ready to proceed. Attorney Grossman, I believe you represent the appellant in this matter. And did you wish to reserve any time for rebuttal?
I do, Your Honor, 4 minutes.
Okay. Thank you. And with that, hold on a second. You may proceed now.
Good morning. May it please the court, Jane Grossman on behalf of Mr. Kalki. I will refer to Mr. Kalki as the husband. We've raised a number of issues in our brief, which we believe relate to an abuse of discretion. And primarily all of those stem from what we believe to be the court's abuse and failing to grant Mr. Kalki a continuance. Sorry, I got a little distracted. As to the continuance issue, we've urged that the failure to continue the trial, the final hearing in the divorce, resulted in a grave injustice to Mr. Kalki, the husband. And we must demonstrate, we believe we have, that the injustice to the husband outweighs the presumption or the policy of not wanting to disturb the trial court's ruling. Here, we've cited a number of examples of injustice to the husband. Neither party had requested a continuance prior to the scheduled final hearing. It was scheduled in March of 2020. All of the trials in the courthouses were continued due to COVID. It was rescheduled to September, continued at the court's own request, and then rescheduled to the 3 days where the trial occurred. No finding was made by the judge that Mr. Kalki was dilatory in attempting to find.
Oh, Ms. Grossman, I think it's pretty clear why the trial court ruled the way it did. One of the reasons was because at the previous hearing, at the motion to withdraw counsel, the court made it very clear that we're still going to trial on these dates. Then Mr. Kalki didn't move for a continuance, as you point out. Instead, the claims on appeal are, I walked in that morning thinking we were here for a hearing on my motions, when actually it was here for trial. But in the same breath, you're arguing, well, I didn't find out until a week earlier when I was served with the exhibits that we were going to trial. And then, you know, there comes up, and you know, then, oh, and by the way, that whole week I was in bed with COVID. I mean, after a while, we get to the point of, well, the dog ate my homework. And given all of this, given everything that had transpired, and given what the court said on the record, I'm having a really hard time second guessing the trial court's evaluation of what was going on here.
Well, I can't disagree with the trial court's statements. I can't disagree that there perhaps is some, at best, confusion on Mr. Kalki's part, at worst, lack of credibility as to why the final hearing should not proceed. But the court is the ultimate gatekeeper. And when you have the parties show up and the marital estate is valued at $3.5 million, there's a claim for permanent alimony, there should be an exercise of caution regardless of the behavior of one of the parties. And that's where I'll get into the issue of prejudice to the wife if the final hearing had been continued, or if this court were to allow a final hearing to be heard de novo.
Well, I think the prejudice to the wife was also pretty clear from the record, in that, one, she was there for trial, ready to go. Two, this had been dragged out for quite some time, a number of years already. And throughout the entire period, the wife was constantly having to file motions to enforce the temporary agreement between the parties. So I think the record establishes a prejudice to the wife too, if this were kicked down the road any further. I appreciate what you're saying, that of course, under the best circumstances, we want to give a party the opportunity to fully and fairly present the argument that he's going to make and present his evidence. But at a certain point, the party brings the results on themselves. And I don't know why on this record we would be able to conclude that the court abused its discretion in saying, you know what, this is the point where that has happened. To the extent Mr. Kalki is precluded from fully making his arguments, at this point, he's brought that on himself and he's got to live with the consequences.
Well, Judge, I respectfully disagree. There are cases where parties have requested continuances multiple times, and then you reach a point where you say enough is enough. Mr. Kalki, neither party had ever requested a continuance. Even if you get to the point where we say, okay, we're not arguing anymore about whether or not we're proceeding with trial. At that point, Mr. Kalki deserved the same type of due process that would have been afforded an attorney who was there representing him. For example, on the very first morning of the 3-day scheduled trial, he said to the judge, "Judge, may I call my forensic CPA as my witness? I have a forensic CPA." And the judge says, "Sure, you call him right now, even though there was 3 days of trial." Now, had he had an attorney and an attorney said, "Your Honor, we need to hear from our forensic CPA later on in our scheduled time or tomorrow during our scheduled time," would that be an issue? With no doubt, the judge would have said, "No problem, it's your time, you schedule your witnesses when you can." But to have a judge say to a litigant, a pro se litigant, "You call them right now, get them on the phone right now," clearly that was an abuse of discretion, and that behavior would not have happened if he had an attorney. He had a business CPA that he wanted to call. When he asked the judge, "Judge, may I call my business CPA?" he was met with a technical objection from the other side. "Oh, wait, the business CPA is not on the witness list," which I understand, a technicality. But at the same time, the wife and her attorney are having one witness testify at the final hearing, the CPA. The CPA did not lay any foundations as to its valuations. Neither party testified as to any values of any of the $3.5 million of the marital estate. It all came from the CPA with no foundation, hearsay upon hearsay. None of that was objected to, and the trial court, as the ultimate gatekeeper, never did anything to say, "Excuse me, CPA or attorney, This is based on Blue Book values. Did we waive records custodian? Your valuations are based on residential appraisals. Where are the appraisers so that Mr. Kalki can cross-examine them if he'd like? None of that was done. That would never have happened if Mr. Kalki had an attorney. Mr. Kalki, during the first morning of the trial, said to the trial judge, I would like to take these exhibits and review them tonight and conduct my cross-examination tomorrow. And the judge says, no, you're not going to do that. You either do it now or you're not going to do it at all. That's unheard of. If he had,
That's because he supposedly had gotten the exhibits the week before, correct?
well, does it really matter though, when you have a 3-day trial and he has a day and a half of that to use as he wishes? If he wanted additional time to cross-examine, when we go to trial, it happens all the time where we say, Judge, I would like to defer my cross-examination until my case in chief. And it is routinely granted without any objection. There would have been no harm to say, Mr. Kalki, yes, you can conduct your cross-examination tomorrow or even on the third day. As it was, they finished this final hearing in 3/4 of one day and 2 days were left unused. That is a prime example of an injustice that should not have happened and would not have happened if there had been a final hearing. There was a pending motion for a vocational evaluation of the wife. She had agreed to it. It was court ordered. She never underwent that. Mr. Kalki filed a pro se motion to compel. By all means, that should have been considered prior to any alimony determination. As it was, the wife was awarded permanent alimony in a moderate term marriage of $90,000 a year. That vocational rehab evaluation should have been conducted, and the fact that it wasn't was yet another example of a grave injustice to Mr. Kalki. Like I said, all of the evaluations were provided by the CPA. Only one witness was called by Mrs. Kalki. When you talk about prejudice to the wife, let's ask ourselves, if this case were continued and kicked down the road 6 months, what prejudice would have happened to her? I understand what you said, but she was receiving nearly $8,000 per month in alimony. She had possession of a home. She was working full time. Her attorney's fees were being paid. And if this final hearing were continued to another day, any additional work that her one and only witness would have incurred or her attorney's fees could have most certainly and should have been addressed at a fee hearing. If they incurred additional attorney's fees because this trial had to be rescheduled, then by all means, Mr. Kalki should be required to pay those. And I stand by that. As it now, she is still receiving each and every month her alimony. The final judgment was stayed by the trial judge because number one, it was repressed, but number two, the trial judge made a determination that we have demonstrated a likelihood of excess on this appeal. So I beg to differ with you, other than the aggravation of having this go on another 6 months, there absolutely was no prejudice. And I would like to say too, the wife in her brief spent most of the time reciting allegations. And I'd like to point out those are allegations of his misconduct or his poor behavior. Your Honor, if only well-behaved litigants were allowed due process and to have their day in court, our divorce courts would be completely empty. We would not be having any trials if everybody had to be well-behaved at all times. And I understand that due process must be meted out evenly, whether the marital estate is $100 or $1 million. But in this case, when you have a 16-year marriage, the marital estate is $3.5 million, and there's a claim for alimony, which I would like to get to. Do we not owe the litigants a fair day in court and mete out whatever consequences to Mr. Kalki should happen at a later time. When you read this transcript, when we read this transcript, it appears that this was a one-horse race. And Mr. Kalki was completely in over her head. And like we stated in the brief, you have to ask the question, he's an acute businessman. He understands the value of these marital assets. He understands there's a claim for permanent alimony. And why would he intentionally show up at a final hearing without his forensic CPA that he had engaged and paid, without an attorney, if he truly did not think that this was going to proceed? Now, was that belief based upon his own ignorance? Was it his fault? Probably. And should he be punished? Should he receive merely the value of his business, valued solely by the wife's CPA, while the wife receives 3 homes, the yacht, the slip space, 3 cars, including 2 Porsches? She gets all of that in $90,000 a year in permanent alimony, and he gets the value of his business, basically. Unless the court has any additional questions on the continuance issue, I'd like to move on to the issue of the permanent alimony that was awarded to Mrs. Kalki.
As you proceed, I will give you kind of you're at 14 and a half.
That was quick.
Time flies.
That's quick.
Yes, it does. On the issue of the alimony, I would like to point out that this case cited the, or wrote the Taylor opinion, which is cited in our brief. And it talks about how very important it is for the trial court to clarify in its final judgment exactly why it's awarding the type of alimony that it is and the amount. And this is not clear in this case. We've pointed out in the record that in her oral ruling, she just states this is an 18-year marriage. I'm awarding permanent alimony. It's a long-term marriage. And Mr. Kalki says, 18 years. And she says, yes, this is 2020, isn't it? And moves on to other findings. Later, it occurred to her that this was really only a 16-year marriage, but she never went on to address overcoming the statutory presumption that this is a moderate term marriage, justifying durational alimony only. She never clarified that she did not consider this still to be a long-term marriage. There's confusion in the record, which says to us, the readers, did she understand the law, and did she just misapply the law? And that needs to be clarified. And I would ask the court to also consider the life insurance and her failure to make a finding as to the net incomes of the parties. I mean, the case law is absolutely clear that this is required. She made a finding as to gross income, but never made a finding as to net incomes. Thank you.
All right. Mr. Miros, you may respond, counsel.
Good morning, Your Honors. I have empathy for Ms. Grossman attempting to explain and or excuse the actions of Mr. Kalki during the course of this matter. But they are not excusable, number one. And number two, they are definitely not the fault of the trial judge here. Not only did the trial judge do everything reasonably possible from day one of this filing to get the case to trial, but she made it as clear as a bell 6 months prior to the trial date the case was going forward as scheduled in November. Mr. Kalki not only had the benefit of 3 fine lawyers, all of whom are referenced in the record, but he also had the benefits subsequent to the last attorney withdrawing of contacting 3 other lawyers concerning his representation. I would suggest that if you were allowed, after having 3 lawyers and then contacting 3 other lawyers, to simply show up at trial and claim that you didn't know the case was set for trial would shut down the judicial system in its entirety. How much better of an example could you have of prejudice to one party when they spend all of their time and their money and their emotions preparing for trial as per the trial court's order, and have the other side show up and say there's no trial set? I'll be very brief on this issue because I think everyone's dealt with it well. This was a matter of not only Mr. Kauke simply not obeying the trial court order after not having obeyed many of the temporary orders during the course of the case. It's him directly misrepresenting the facts to the judge related to why he wasn't ready for trial. He goes from one excuse to the other and then finally makes one up at the end that he was sick. This simply should not have been tolerated by the trial judge and wasn't tolerated. Now, the argument that somehow he didn't have an opportunity to produce his evidence, for example, why wasn't the vocational evaluation dealt with? These are all things that should have been dealt with prior to trial by Mr. Kauke and were not, for whatever reasons. I don't know why, but certainly not our fault. He had every opportunity to present his evidence. He simply didn't prepare for trial, whether it be pro se or by a lawyer. He had a forensic CPA. He just didn't have that person there or ready for trial. It wasn't my fault. It wasn't Judge Newton's fault. It was his fault, 100%. The only competent substantial evidence before the court entirely supports the ruling and certainly supports the denial of a continuance. There are so many other examples related to that, but I'm not going to dwell on them. I think we've covered them. Let's now deal with the permanent periodic alimony award. I respectfully submit to the court that the trial court's award is not just supported by competent substantial evidence, but is supported by the only competent substantial evidence before the court. The law, the statute itself, and or all the case law we've cited clearly supports the entitlement to an award of permanent periodic alimony with a moderate term marriage if you provide the appropriate evidence. I hear the judge did specifically find with good reason that no other form of alimony was appropriate other than permanent periodic alimony, and the very clear and very convincing evidence supports that finding. Here, the facts were, again, undisputed that Mrs. Kauke was a 47-year-old woman who was an immigrant from Venezuela, who had very limited job skills, who was earning $17 an hour at the time of the final hearing, who had no identifiable rehabilitative plan, no ability whatsoever to support the marital style of living going forward. And very critically, that she was earning $2,200 a month, and he was earning, by the undisputed evidence, $40,000 per month. She had no chance of ever being able to support herself in a reasonable standard of living going forward in accordance with the marital standard. It's also critical.
Mr. Maros, let me interrupt you there because there is something about that that's troubling me. The numbers that you just quoted, my understanding, are the gross income. And I understand that you were just quoting them to show the sort of generally the ability to pay and the need for alimony. But my understanding of the actual alimony calculation is that it was based on Exhibit J.
That's correct, Your Honor.
And I'm not, help me work through this because I'm not sure whether your argument on appeal is that Exhibit J properly calculated alimony based on net income, or whether your argument is, well, it's not really clear if it was based on net income or gross income, but at the end of the day, it doesn't matter. And so I want to be very clear as to what the basis, what your argument is, because I agree that there are no findings with respect to net income, certainly not in the final order. And I'm having a little bit of a hard time sort of working my way through Exhibit J to make clear exactly what happened.
Sure, let me do that with you, Your Honor. And let me say that the award is definitely based on net available income. If you look at our Exhibit J, if you have it available, and it is in the, we particularly made it a part of an appendix so it would be easily findable, and it's A12 of the appendix. And this is the way that we always prepare these documents, and it's the right way to do it, and it is very explanatory. What the document does is first identify gross income. You'll see at the top under the husband, his gross income was $40,961 a month. The wife's was $2,210 a month. You then back out the alimony of $7,483, giving him income after alimony, but before deductions, of $33,479. We then back out all of his entitled deductions, his taxes, Social Security, his health insurance. And as you will see, and this is the reason we call this document what we call it, the available net monthly income to each of them and is $21,101 to the husband after all deductions, and $9,097 a month to the wife after alimony and income and all deductions, which in the bottom column shows that it meets her need and shows that he has a surplus of $9,983 a month. Our numbers are 100% totally based on net available income. Gross income is on there because it has to be, but it's a net available income analysis.
So is the 21,101 his net? That's not his net income before alimony. That's with the alimony taken out of the gross income?
Yes, ma'am. It's showing the alimony, his total net available income after all of his deductions. This
after
is
all of his deductions and alimony?
Yes, ma'am.
Okay, so
After
you're taking the alimony out of the gross because of the tax implications, or to account for any tax implications?
Well, yes, you have to take, yes, ma'am, you have to take the alimony out of gross for this spreadsheet, for this calculation, because that is then going to determine how you arrive at his deductions. So this is based on the theory for all of the case law related to net versus gross, is that for purposes of determining where people stand, you have to use net numbers. You can't use gross numbers. And that's what we did in this document.
Okay, so if we wanted to very simply find out what his net income would be before alimony was taken out, we would just add the 21,101 plus the 7,483.
Exactly.
Okay, so even though there's no express finding as to his net income to determine whether alimony could be taken out of it, that's obvious from the exhibit.
Yes, and the exhibit was accepted by the court and referenced by the court specifically in the final judgment and in the transcript. It's the only evidence before the court, and it's supported by competent substantial evidence in all respects. I remind the court that Mr. Berg not only testified and explained all of this, but our trial documents have all of the backup. It has all of the expenses, all of everything, financial affidavits, full backup for everything. So my comment related to there being no abuse of discretion here is that we established that this is the only fair way to deal with this alimony claim going forward. And what it does is gives Mr. Kauke the entire ownership of a business that has grossed an average, that has had net income to the family. And by that, I mean income payable to the family before taxes of $500,000 a year for the last 3 years. He's left with the entirety of that, with his only obligation being paying alimony of $7,700 a month, and then a substantial excess over and above that. This is a situation where the result by the trial judge, in accordance with Conacris, clearly did not transform either party from prosperity into misfortune. I'm not sure how much time I've used, but I can briefly deal with the life insurance if you wish. The life insurance, all the findings
10
were.
and a half.
Okay, great. The life insurance, all the findings were there that should have been there. And contrary to virtually every other case, this was an existing life insurance policy with an existing premium that insured the husband's life for $1 million clearly identifiable. The court found special circumstances, which here were pretty obvious, is complete failure to comply with prior court orders, and that he got the entirety of the business, which upon his death would have left no ability for her to receive her alimony or support herself going forward. The imputation of income argument is completely without merit. They're claiming that the court should have imputed income to my client when she received no liquid assets whatsoever. She received the home, some real estate, and no liquid assets, and all of the case law, contrary to their argument that you should consider all of the assets for purposes of imputation, is just wrong. It's only assets that are available to impute income. And that's
Was there evidence in the record that the rental properties were operating at a loss? I thought I remembered reading that somewhere.
Yes, there was. There's no evidence as to the specifics, but there is definitely no evidence of any receipt of income from the rentals. And of course, the big thing here is that cannot be overlooked is Mr. Kauke didn't present any evidence of what the imputed income should be, if any. He presented nothing, nothing whatsoever. So to make a long story short, and the last comment I would have is counsel made points about all we did here was offer a CPA, and that's not really fair to this gentleman, and it's not really competent, substantial evidence. Well, we offered very specific, straightforward testimony by a highly qualified individual with all of the backup, identifying each and every issue before the court, buttressed by all of the backup documents, and buttressed very much by the testimony of Mrs. Kauke. There is not one finding here that is not completely supported by the competent, substantial evidence before the court. This gentleman had every opportunity to present evidence to the contrary and simply failed to do so as a result of his own dilatory conduct and neglect, specifically in accordance with his behavior throughout the course of the entire trial. The ruling should be affirmed. Thank you very much.
Excuse me. Attorney Grossman, you have your 4 minutes for rebuttal.
Thank you, Your Honor. If we were only here on one issue, and that issue was our complaint that Mr. Kauke was denied the opportunity to present the testimony of his forensic CPA during his allotted time, this would require reversal. This forensic CPA was critical not only to the valuation of the marital assets, but Mr. Kauke had a claim for non-marital assets, which he consistently listed on his financial affidavit, in excess of $1 million. To deny him his one witness who could clarify that and present testimony requires reversal. It would have never happened if he had an attorney or an attorney made that request. He should have been allowed to cross-examine Mr. Berg, the CPA. The fact that it did not happen is reversible error. He had the time allotted. He should have been able to use it. And I take umbrage with my respected opposing counsel when he says the testimony of their CPA was factual and this and that. It was not. It was based upon hearsay on hearsay. Mr. Berg was allowed to testify as to what somebody in Mr. Kauke's office told him, and then he testified to that before the court. Their residential appraisers' reports would have never been introduced into evidence if Mr. Kauke had an attorney and knew how to address those evidentiary objections. And that's addressed in the case law. Whether or not his lack of skill greatly impacted the result that was meted out. So we can say Mr. Kauke acted, poorly. We can say he did not tell the truth. We can say he was a cad. We can say he was this. We can say he's that. The bottom line is, forget all of that. If he showed up that day and never made a complaint about moving forward, and he was denied the right to present his forensic CPA, that is error as a matter of law. And it should not be allowed to happen simply because he's a pro se litigant. On the issue of the alimony, again, the trial court's statement, no other form of alimony is appropriate. I'm sorry, that is not sufficient under law. The law requires that there be findings of fact. This statement that the wife is entitled to permanent alimony and no other form is appropriate, that's a legal conclusion, and that does not meet the specifics of the statute. As far as Mrs. Kauke.
Before we leave that point, that subparagraph that's a subparagraph of what? Paragraph 6, where that appears, where it says is the only appropriate form, that's subparagraph F. But there are 4 to 5 paragraphs immediately preceding that, laying out a whole number of facts. Is that sufficient to support the conclusion? And I will note there's no number 7. Well, yeah, there is on page 5. It goes, oh, that's a G. I dropped my glasses today and they're little warps. Okay, that's not a 8, that's a G. Okay, so there's a number of paragraphs in 6 where she discusses that.
Well, she never discusses, number one, she never states that this is a moderate term marriage. She doesn't make any findings of fact which justify deviating from the statutory presumption. She makes findings of fact as to the difference of the incomes and things of that nature, which is required under 61.08. But if you're going to deviate from the statutory presumption of durational alimony, you have to make findings of fact, and simply saying durational alimony is not appropriate is not a finding of fact, that's a legal conclusion.
She has no reasonable plan for rehabilitation or additional education and did devote her time and energy into this business.
That is not a finding to justify PPA. And when we're talking about education, I'd like to point out that Mr. Kauke too is an immigrant. The English language is not his first language. He was at the same disadvantage as she was. So to portray her as poor Mrs. Kauke who can't find her way in America is simply not an accurate representation.
Well, I think that's sort of exaggerating what the trial court found. The trial court found that she was a 47, I think, year old woman who had spent her career working in the business that the two of them had built together. She had a high school education from Venezuela, and she was working basically as the office administrator. And so I don't think, I think you're sort of exaggerating the court's very fact-based findings and support.
Well, Your Honor, when you read the findings of fact that the judge sets out to support the $7,500 per month in alimony, it's very clear that it's tied to a disparity of the incomes. She will no longer be working in the business. And the case law that we have cited makes it abundantly clear that disparity in incomes alone is not a justification for permanent alimony. And we completely ignore the fact that she was awarded $3.5 million in assets, or excuse me, 1/2 of $3.5 million in assets, multiple homes that she can sell. She can sell a yacht of $150,000, multiple cars. This lady by no means was left destitute. The husband, on the other hand, was awarded a business which was, the valuation was relied on, the trial court came solely from their CPA, which is another reason why the forensic CPA should have been permitted to testify and clarify what their opinion of the marine construction business was worth. Because as it was, they lumped up the marine construction business on one side and gave the wife all of the other assets based upon their valuation and their valuation only.
Thank you, Counselor. We are well beyond the time that you reserved, almost double.
Thank you very much.
Thank you all for your presentation today. We hope that you all stay well, and will allow you to be transferred over to the departure facility, if that's a good phrase. I don't know.
Thank you.
According to my clock, it's 11:33. We're going to take a recess. We will be back at 11:50. Okay, we have our whole panel. And we have one case ready and remaining. I guess at this time, if you would kindly bring over the oral list for the case of Lana versus Alexander, the next case on our docket today. Okay. Mr. Lana, my screen shows that you are unmuted, or that you are muted, pardon me. You need to unmute. Thank you, sir. Will you be presenting the argument this morning? Afternoon. I'm sorry, well, it will be shortly afternoon. I guess it's still technically this morning.
No, I have an opening, and then Ms. Silver will be presenting everything else. Reserving just first few minutes to talk.
Judge, 1 second, please.
So there's someone else going to be presenting then today?
Yeah.
Okay. Are they there with you?
No, they're going to be coming in. They were, yeah, there we go.
Hello?
I
hear
hear a voice, but I don't see anyone.
It's Eva Lana Silver. Hi.
Hello.
We're dividing our time. Max has an opening with some of his concerns, and it's about 3 minutes. And then the balance of the 15 would be mine, and then 5 minutes reserved for rebuttal, which will be mine.
You have a total of 20 minutes, so you will be going 3, 12, and 5?
Yes, maybe 4 for Max, wherever he finishes.
Whatever he uses comes out from the 15, and then we can segue in to the next speaker right after that. And as I'm the timekeeper, I will let you know when you arrive at the 15-minute destination so that you can decide. I'm sorry.
Oh, forgive me. I was trying to work my video.
Okay. I'll give you a moment for that. Is your camera turned on by any chance?
Yes. Okay.
Oh, you're not. We still only see Max. Wait, there you are. You're with us now. Good. Fantastic. Okay. Then with that be resolved, we can proceed. Okay, Mr. Lana, you have the floor, sir, and you may begin.
All right. Hello, my name is Maximus M. Lana. I am a 22-year-old pro se appellant and currently suffering from a severe concussion. So I'm limited both in time and by physical ailment. I will also be reading, so I do not lose my train of thought. Today I'm speaking for the first time in 11 years because I was 11 years old when the court case in this state began to adjudicate my rights to my grandmother's estate, even though her estate is under the exclusive jurisdiction of the courts of New York where she was domiciled. And so I would like to raise subject matter jurisdiction error because it is fundamental and needs to be reviewed by this court. I understand that a fundamental error in a subject matter jurisdiction can be raised at any time, and that it's the court's duty to notice them, even if the parties don't. The appellate courts of New York issued a landmark jurisdiction case in 2018, citing a legal and evidentiary basis for their exclusive in rem jurisdiction. If the courts of Florida want to have continuing jurisdiction over the property in this case, which is not located in Florida, then I believe the courts must announce the basis for this jurisdiction, because this has no personal jurisdiction over me otherwise. I am and always have been a domiciliary of New York. The jurisdictional error has been compounded by a 14th Amendment violation because I have never been appointed an independent representative by the courts of Florida, and the entitlements to the judgment in this case were decided when I was still a minor in January of 2017. I was substituted into this proceeding in October 2017, shortly after I began college, and only a few weeks before the October and November 2017 hearings for fee amount were then held. This was not fair to me, given how many documents need to be reviewed before a six-figure judgment is awarded, and even my counsel, whom I could only afford for the fee hearing, asked for a continuance and was denied by a judge who was later disqualified for prejudice. So I am now facing judgment that is a result of nested fundamental errors. And may I ask, why is this the case? I also understand that there may be a third fundamental error caused by allowing one co-defendant to act as counsel to another. Though defendants in a tort and civil conspiracy case may be entitled to have common defense, they are not entitled to help each other and then bill for attorney's fees, nor are they entitled to use an attorney-client privilege to subvert discovery. I am not aware of any precedent for this, and if the laws of the state permit these fundamental errors, they violate U.S. state constitutions and thus give rise to several federal claims, since I belong to 4 protected classes and I have been discriminated on the basis of all these jurisdictions. There is no explanation for why I have not seen a penny of my inheritance, and my distributive shares have been used to pay Mr. Philos for defending his co-defendants. This is why we have recently requested that case 21-2165 be resolved before a final judgment is approved in this case, because there is no point to reviewing an award of attorney's fees granted to someone who may not be entitled to those fees as a matter of law. This much I can understand because it is fundamental. And so I ask this court to review these issues before issuing a final order. Thank you for your time.
Thank you.
So has my clock begun?
It's still running.
Okay. I don't know how to do this with Zoom, but I'm going to need documents because there's 16,000 pages. So I'm going to just pause the video so that I can get back my screen and speak to you largely with record citations. I want to just dovetail one thing about what Max said here, because there was a recent, rather frantic attempt to get in a motion for consolidation, abatement, and stay with 21-2165, which is an order requesting disqualification of Mr. Philos as counsel, and that was denied by the lower court and is on is a non-final order on review. I will say this: the answer brief filed by Appellees opens the door to this, because on page 4 of it, apropos of nothing, it says, said counsel was never served with process or appeared as a party in this case. I refer you to record page 12,457, 12,297, where literally a caption is being amended. Mr. Philos is present. He gives his spelling for the amended caption. And then on February 13th, 2015, an order gets issued. So I don't know if I can screen share. I was told in training you cannot. I can't do demonstratives because I'm not there. So I'm actually have many documents open in order to reach the many points in this. But I do take, Max has been puzzled by this non-adversarial sort of approach to have co-defendants in a conspiracy to claim, be defendants for themselves, lawyers for each other, and then bill. No precedent that I could find. And the courts did not listen to my many objections to this and treated it, normalized it indeed. And indeed, Mr. Philos first ignored it and then raised this notion of service and process at the first day of the motion for summary judgment hearings. And those are in the record, the hearings for June 1st, 2017. Certainly at the end of discovery is not a time to let everyone know that you've decided not to don the yoke of defendant. I'm not sure why someone would feel that they are defendant proof. We've sued presidents and princes, and the law is the law. So more of that was said in my emergency hearing, and there are supplemental authorities that were submitted on this point exactly, because it is a fundamental error and it's not going away, nor is the subject matter jurisdiction. And that has been put before this court since 2018. I will judicially notice the court's own records. Certainly nothing can stop this court from looking at its own records when it decides this, and these are not things that one can move past. As far as the substantive issues here, as the brief says, there's a problem with the evidence. There is really no substantial evidence to support a six-figure, now with insurance, attorney's fee. And the evidence that is cited in the reply brief is in the answer brief is very scant. Due to the pandemic, I could barely get the briefs done. That's another unexpected disadvantage of being in the wrong jurisdiction, is we now have, New York courts shut down for a year. Meanwhile, Florida is asking me to do 3 appeals, and we're Wuhan, USA. So that shows how a sort of defect at the very bottom, at the base, can have these ripple effects beyond, just being a fundamental error. So the reply brief did not get in there, and I apologize for that. And but I did spend a great deal of time taking a 14,000-page record and condensing into volume 1 of the appendix, which is before you. And you can see very clearly the flow of the proceedings. And this case was pretty much docketed to summary judgment and done within eight months. And in the 6th month, we discover that a defendant is not choosing to be a defendant in any event, but rather counsel to the remaining defendants. So that's, I have no words on that. The dean of my tax law program also has no words for that. So I don't know where else to go. Now, as far as the methodology and his talking just about what's going on with the billables, assuming we have no fundamental errors and we just get to the nitty gritty of what's the problem here, you will find no substantial evidence for what's going on. And a total insufficiency of evidence is equal to denial of due process, and therefore also a 4th fundamental error, FB v. State 852 Southern 2nd 226. That's Florida Supreme Court on that, and that was in the supplemental authorities. I will point you to the record, which due to its length, and I don't have a visual, I'm just calling out record numbers. Give me a moment here. The discovery that was given to us was actually a draft affidavit, which wasn't even an affidavit. And so there's no original records that were, there's double hearsay records were submitted. This is very well detailed in the actual fee hearing, which was done by our counsel at the time, Dan Bushell. And in the transcript of the fee hearings, some real anomalies occur. For example, there was an affidavit brought to court that Mr. Fields brandished on the first day of hearing. There are 3 days of hearings, one in October 24th, the other is in November 13th, earlier in November, and then the final one is November 13th. The early November one had absolutely had the bulk of it and the experts and the testimony. So that's kind of the core of it. And in that, the actual experts were sequestered until Mr. Fields could finish testifying. And they were sequestered the first day entirely, which is unbelievable because they're experts. They're there to actually, contribute to the proceeding. And so during that proceeding, the first day, Mr. Fields brings, just a second, sorry, I'm gonna get my timeline, here we go, okay. There is all over the appendices, every appendix of the 3 appendices I submitted, the first one is literally top to bottom proceeding, complaint to final judgment, to even motion for rehearing, which takes us to January 2018. The final judgment was subsequent to the 3 hearings. The 3 hearings are October 24th, November 13th, all 2017, and 10 days later, November 13th. The first day we had to have a continuance because even the court had to admit we had 0 evidence. What was handed to me, because I was pro se until that point, and we had to reallocate funds and couldn't get a reply brief from this attorney because we ran out of funds. We had to move our appellate attorney over to this and ask him to come in. As I was a second-year law student, I had never done a fee hearing, and this obviously is technical. And then, Max, who you'll see was actually substituted into the proceeding on October 4th, 2017. So that puts us 3 weeks before the hearing. And by the way, Max also didn't receive a host of notices like the protective orders. I mean, it's just a due process travesty. But getting to the hearings, the first day of hearing was continued. And that's why we couldn't have a fee hearing until November 3rd. So 5 days later, Mr. Fields submitted what was double hearsay. And that's all in the record. And you can see it well organized in the appendices I created. And at that hearing, what happened was he had an affidavit, but he didn't want to submit it. And then the judge said, well, you can go submit it later, but he never did. Instead, he gave us these unsigned bills with draft all over it, and then called them affidavits. And so got everybody to call them affidavits, even though they were unsigned, which is the sort of definition of an affidavit. And so basically we have double hearsay documents. We also have some inconsistencies as far as what these documents could mean. If you look in the appellate brief, in the summary, I put a picture right up front of what's called block billing. If you compare Mr. Felix's October 6th deposition, where he describes his billing practice, it's completely at odds with his actual testimony under oath. And the bills sort of show it. He claims always, he makes these notes to himself and on scraps of paper, and then puts them into some intermediate situation. And that's called block billing, which you can see it's just completely blacked out. What's odd about this is it serves no purpose other than to leave no data metadata in the document, because block billing, and I wish I could show it to you, it's on, it's actually in the summary I took of the initial brief, is probably the fastest way to find it. It's just a blackout, and literally the times were put and run into each other without even a return, a date, a space, serve no logical purpose other than to create something that either couldn't be read or didn't have a chronology. It could be created on a plain text file. So basically this eventually Mr. Fields then steps away from the idea that he has block billing and then says, no, I go right to the final bills. So there's three ideas here. One is I get a piece of paper and then I have an intermediate record, and then I make these records, and then I gut these records for the court convenience and just extract this work on this case, put affidavit all over it, and then hand it to you unsigned. And that clearly wasn't going to be competent evidence for $100,000 in fees. And then the second theory changed during the second day of the November 3rd hearing, when Mr. Fields was on the stand, and became, no, there is no intermediate record. I just go straight to the very records you see, making them contemporaneous records, when before they were like a hop away, because there was this block billing in between. And so I created a demo of this, the methodology, in Appendix 2 on page 560, which basically goes through this. And if you compare the October 6th deposition prior to the fee hearing, when all I had to work on, by the way, I had to go into depositions as a law student with just, these affidavits that were not really evidence. And throughout the deposition, he talked about intermediate records, but then suddenly they were gone. So
Forgive my interruption, but I need to keep my commitment to you. You have arrived at your 15-minute point, and you're beginning to invade the time that you have reserved for your rebuttal. The choice is yours whether to go forward or to stop. But at 20 minutes, that's all you get, as they say here.
Well, I will say one thing. There's also the 1.525 violation for filing a motion for sanctions in September 2017, 8 months after the final judgment, after we'd adjudicated the entitlement and the fee amount. So all these are serious problems, I believe. I would like to reserve my rebuttal. Thank you.
Okay, thank you.
I'll return to the room. Sorry, I had to look at documents.
Mr. Felix, you may begin.
Thank you, Your Honor. If it please the court, I'm George Filos. I represent the appellee in this case, Plato J. Alexander. The appellants filed a non-conforming amended initial brief in this case, and likewise proceeded on an oral argument, which is contrary to the court rules by bringing up matters which were not mentioned in the briefs whatsoever. This court obviously has subject matter jurisdiction of this case because you all have subject matter jurisdiction of final judgments of the circuit court. And that is what is being appealed, the final judgment of the circuit court. Mr. Lana mentioned that the court never had personal jurisdiction over him. However, he's the plaintiff that brought the case. And when you file a case in court as a plaintiff, you are submitting yourself to the jurisdiction of the court. I mentioned that the amended initial brief filed by the appellants is non-conforming because they didn't follow the appellate rules of procedure nor follow the requirements of the court for presentation of issues for review. In the statement of the case and facts, there are only 3 citations to the record on appeal, 2 of which are incorrect. And obviously the statement of the case and statement of the facts is the foundation upon which you can make your argument in the argument section in your brief. Now, we've heard something about the 3,892 page appendix that the appellants filed, which condensed the 13,000 page record. However, that brief only contains 1 page with references to the appendix. There are 3 references to the appendix on that page, and 2 are inaccurate and 1 are misleading. So our point, as we made out in the brief, is that the bulk, if not all, of the arguments on appeal were waived by the appellants. This court is not obligated to rebrief a case for the appellant. You're not obligated to ferret through the record to find facts that might support an argument or come up with arguments for the appellants, but that's exactly what they ask you to do. On page 21 and page 22 of the initial brief, as the appellants are talking about the issue of entitlement to fees under the proposal for settlement rule and statute, they specify hearings and documents in the lower court, where they say, here are hearings and documents in the lower court that specify our grounds. And now I'm quoting from their brief. All aforementioned arguments made and authorities cited in the lower tribunal are incorporated by reference here and are sufficient as a matter of law to result in reversal of fee and cost entitlement based on offer of judgment. That, by the terms of the case law, is a waiver of the issue. Appellate's court will not consider issues unless they are properly raised and discussed in their briefs. As to the issue of section 57-105 entitlements, on page 27 of the initial brief, the appellants devote 1/2 a page to the 57-105 entitlement. There are no cited cases, and there's in essence no argument made, and neither the statement of the case or facts cite in the appellant's statement of the case of facts cite any reference to the record on appeal regarding that issue. That issue is waived. There was one statement made by appellant that the 57-105 motion for fees was not filed until after the final judgment. But as mentioned on our brief, the case law is very clear. It's the service of the motion rather than the filing of the motion, which keys in the timeliness, and it's undisputed that the 57-105 motion was filed before the final judgment in this case. Likewise, as to fee amount, the appellants claim that the judgment below was not supported by competent, substantial evidence. They devote 1 paragraph in their brief to that issue on page 32. And their argument is, the record, I'm quoting now, the record below demonstrates that the fee awarded by the circuit court was unsupported by competent, substantial evidence and therefore needs to be reversed. Neither in that argument, if you're even going to call it an argument, or in the statement of cases and statement of facts, do appellants cite any reference to the record on appeal regarding that issue. That's also a waiver of that issue. Aside from the issue of waiver, even if waiver didn't apply, the issue of entitlement under the proposal for settlement rule and statute has already been decided by this case in the first appeal, which is the plenary appeal from the summary judgment in favor of my clients, in which this court awarded my client appellate attorney's fees on the basis that there was a valid proposal for settlement under the proposal for settlement statute.
Mr. Filos, I think I'm going to have to disagree with you on that. Because at the time that we awarded the attorney's fees, the issue of entitlement was not right. We did not have jurisdiction over it. So I think our award of fees pursuant to the proposal for settlement was made with the understanding that is contingent on the assumption that it was a valid proposal for settlement. That was not resolving as a matter of law that you were entitled to fees pursuant to the proposal for settlement, because that was not yet ripe for adjudication. So I think you're jumping the gun on that, because we didn't have jurisdiction to decide it. And if we had, that would have been invalid.
I would respectfully disagree for this reason, Your Honor, that the lower court had already ruled that we were entitled to fees under the proposal for settlement statute, but entitlement was decided by the appellate court, by the trial court, prior to the appellate court entering its award, I believe. It's only the fee judgment as to amount that was subsequent. But in this court, and the second point I wanted to make is that this court's award of appellate fees in the plenary appeal was not conditioned. And I've seen many orders of this court conditioned on subsequent findings of the trial court. But the trial court had already ruled that we were entitled to fees under the proposal for settlement statute.
That's true, but my point is, and that's absolutely true, but you're arguing law of the case. And what I'm saying is we have not yet decided, because we did not yet have jurisdiction to decide entitlement.
Well,
even though that had already been decided and it theoretically was encompassed in the notice of appeal, it was premature. We don't have jurisdiction to determine entitlement until the fee award is final. And that's when we can weigh in on entitlement and amount.
Your Honor, we've cited in the case, the Crouch case, which was this court's case from 2008, which I believe is identical in the facts. And to look at it even a little further, if this court, to accept Your Honor's proposal, if this court decided in this appeal that the proposal for settlement was invalid for some reason, so there's no entitlement as to proposal for settlement, then you would have two direct and contradictory opinions of this court, because the appellate court in the plenary appeal could not have awarded appellate fees unless the proposal for settlement were valid. And then you'd have a situation where you have a mandate from the first appeal requiring the trial court to award fees under the proposal for settlement, and then a decision of this court saying we're not entitled to. And that's exactly why you have law of the case, not to have contradictory opinions. So I would respectfully disagree, but moving on from that, Your Honor, even if the law of the case didn't apply, I wanted to talk a little bit about the merits of the, aside from waiver and law of the case. Regarding Max as a as a minor, and conflict of interest. The initial complaint in this case sought to do away with Max's grandmother and Eva's mother's estate plan, which in fact effectively gave everything to her grandchildren. And the initial complaint asked that her estate plan be overturned and Eva and her sister would inherit her mother's estate and in essence disinherit the grandchildren. And we raised the issue. We said, that's a conflict of interest. Eva and Max have a conflict of interest in this case. And Ms. Silver filed a motion and said, number one, there is no conflict of interest because we're going to dismiss our initial complaint and we're going to file an amended complaint, not seeking to overturn the estate plan, but for tortious interference of an expectancy, and our interests are aligned, which is exactly what happened. And in fact, Ms. Silver also stated that she's the court-appointed guardian of the property of Max. So there was no conflict of interest here requiring a guardian ad litem be appointed. In fact, it was the appellants themselves that opposed the appointment of a guardian ad litem. As to Max as a minor, I know of no case, no rule, no statute which says that when a guardian of the property of a minor files a claim in court, they're not subject to the same rules and statutes regarding attorney's fees as any other litigant. And I think it's also very important in this case to note that before the judgment was entered in this case here, Max filed a motion granted by the court where he said, I'm not a minor anymore. I want to join this litigation as an adult. That was his choice. That's the choice he made, and the law is clear. He stepped into the shoes of Eva as guardian of the property for Max, as to Max as an adult. And so there was nothing inappropriate, there was nothing unfair about this judgment being entered against Max. Just briefly on 57-105 entitlement, and may I ask when I have 3 minutes left, Your Honor, if that's...
Well, you're a little late for that because we're at 13. No, I'm sorry. You don't have any reserve time. You're at 13 and about half, so you have 6.5 minutes left according to my mathematical skills.
Thank
I
you.
caution you, I was a liberal arts major, not a math or science.
I trust your mathematical skills completely, Your Honor.
You can thank the nuns then, because that's who beat it into me, I guess you'd say. Made me learn.
On 57-105 entitlement, it's important to note how brazenly frivolous this lower court action was. And of course, frivolous, you don't have to prove frivolousness for 57-105 these days. The whole basis of this suit, which took years to litigate, was allegedly that Eva's mother, Max's grandmother, Paula, was ill. She was terminally ill. And that these are the allegations of the plaintiffs, that their mother and grandmother intended to gift all their assets to them while she was still alive. And she would have done so had Eva and Max been informed of her illness. But because they weren't informed of her illness, they didn't have the opportunity to encourage or facilitate those inter vivos transfers. And that was a tortious interference with their expectancy. Shockingly, prior to that complaint even being filed, the appellant filed in a probate matter, the related matter, statement saying, Eva asserts that her mother intentionally hid her illness from her family. Eva asserts her mother intentionally hid her, her assets, her finances, her illness from her family. The pith of their complaint was known by them to be false even before they filed it. If there's any case that you can think of which deserves a 57-105 entitlement to fees, it's this one. And even that, the judge also found and noted that in his summary judgment, but also found you can't have a tortious interference when there's no tort and there's no duty for one person to inform another of their medical condition. So this was a baseless, frivolous lawsuit, which begs for 57-105 entitlement. Regarding the competent substantial evidence for the fees, the raw billing records were introduced into evidence. The client billing was introduced into evidence. Now, it is true that the raw billing records do have things blocked out, but that's because, as was testified and explained, counsel was representing appellee on multiple matters. So the matters in other cases for which compensation were not sought in this case were blocked out, number one. In addition to the records, the counsel testified at length to the fee. Counsel's expert testified at length to the fee. The judge adopted the figure that was testified to by the appellee's expert witness. That constitutes competent substantial evidence. The law is clear. Billing records, attorney testimony, expert testimony, that's what comprises competent substantial evidence for a fee amount. There was a mention.
You have 2.5 minutes left.
Thank you, Your Honor. Regarding block billing, I'll point out the statement, and it's mentioned in our brief by appellant's own expert witness, stating that he didn't find the block billing objectionable. Of all the hours introduced in this case, there were about 25 hours or so that comprise compensable and non-compensable matters. And the law is very clear, as long as the attorney testifies and allocates them, that's sufficient basis to award fees on that basis, which the record shows. The testimony was that the attorney went back, looked at those, allocated them. If he wasn't sure of the time, he went back to the actual file if necessary. So there's competent substantial evidence. The lower court belabored over this fee hearing over 3 days, made multiple accommodations to the appellants who were represented by appellate counsel. So we respectfully ask the court to affirm the judgment of the lower court in this matter. Thank you. And we yield back the rest of our time.
Do I start?
Just a second. I want to make sure that I'm set to write down my notes on your presentation in the right spot.
No problem.
Thank you. You may proceed.
Okay, I'm running a timer. Sorry, I'm going to talk really fast. With regards to Max, settlement, never offered to him. Record, 12,219 to 12,297. Responses to why the settlement, the entitlement should not be had, given at the entitlement hearing. Max could not be offered settlement because you need an independent settlement. I was appointed as guardian of property in New York, not in Florida. Two, not just one, two fiduciaries were supposed to marshal the assets that are in the motion for summary judgment dismissal. The motion for summary judgment dismissal, even in case 16-5069, says that the personal representative was supposed to go for these assets. So we filed with my attorney this case, and we had to file it here because they had fraudulently initiated a probate here, and New York took 4 years to sort it out in the appellate level and the Court of Appeals. My case is held in every treatise from Surrogates Heaton to New York jurisprudence. I wrote the entry for Westlaw. Okay, so basically, when I also wrote this brief, I am sorry it's not conforming. It was November 2020. We were in a meltdown. We are not slackers here in New York. Our courts just opened right now, and I had docketed 3 appeals. I had to pick and choose. I have read your opinions, especially Judge Casanova, big fan. And I just thought, well, they're smarter than me. What I did was what I could do. I took that 13-page positive record. I made one big long running record with a table of contents. I said, here are the facts. And then I took all the authorities I had, and I didn't bother putting them everywhere. I made them by theme. They're not alphabetical. They're thematic. I think you know what to do with the case law. I don't have to instruct this court. So I did what I could under the circumstances. There's also a very young pro se person who submitted the work. So for its defects, mea culpa, I apologize. I put the law and the facts together. The law is nothing more. And that's what I learned in law school. As far as the sanction is the most painful of all, because even Judge St. Arnold, who actually had in 4205, you reversed a 14th, he sanctioned me without hearing or notice for raising domicile. On 3,000 pages, I got sanctioned in Florida. On 1,500, I made the books in New York. But Jack St. Arnold, he did issue in November 2011. He would have issued, and I submitted it last night with my motion to consolidate Appendix 1 that shows how the jurisdiction was stolen. If I don't have any jurisdiction in New York because I've been duped, I went to law school. They duped me twice. It wasn't going to happen. I went to law school for my son during the pendency of this between 2015 and 2017, got a degree in 2 years because we had attorneys dropping off, sanctions weaponized, and the wrong jurisdiction, and New York turned me away. I had to overturn 2 surrogates in New York to get the jurisdiction to repatriate my mother's will because all the property is in New York. So at the moment this was filed, which we were confronting a 4-year statute of limitation on undue influence, why would Judge St. Arnold actually appoint Gary Fernald to basically marshal, and he puts it in order, $220,000 worth of assets that the Alexanders somehow got within a year of when my father died. And I will say this about my family. I asked my mother to give everything to my son because I don't even collect child support, and his father's a senator. So this was then uncovered in a letter that's in the record for my mother. So saying that we have overreached, there is an apartment, please read the reply brief in 2D165069, where I explain what has been distorted so terribly in this last bit that we just suddenly woke up and decided we were going to pull a fast one. No, my mother disappeared for a year, and because they wanted the co-op, they didn't transfer the co-op. They just kept hoping, I guess, that she would live or they wouldn't tell New York. I have no idea. This is another situation probably to be taken up in another jurisdiction. New York has those records. Mr. Fields and the Alexanders participate in my mother's last case, which survived her, for that co-op, which incidentally was assigned to the Alexanders 90 days before she signed the will. Before that, it was an access. We were living there and we lost it by operation of law because it's a Mitchell-Lama co-op and they didn't know that. So net, this, I would like to say, if you could just look at that first appendix, if you just see the record and put together the law and yesterday's filing, which speak to these fundamental errors that I cannot speak about them because I've carried the fate of my son, and kindly understand he was never offered a settlement because I couldn't accept a settlement. Plus they sneakily put the settlement, even though there's millions of dollars writing on this, under 14,000 so that it wouldn't actually trigger the Florida laws about guardianship where, you know, if a minor has to have a settlement above a certain threshold, you need somebody in there, you know, but to wit, there are 2 infants at this moment in the probate that have no guardian. How does this happen? This is an interstate, it's a federal case. It's got two states fighting for probate. So how do the Florida kids have nothing? My son aged whole childhood gone, but there are 2 infants there. So I ask you, please, the facts and the law. I don't need to school this panel on that, and I did the best that I could. But what we heard now, that was very far. That was spin. And as Mr. Fields have it, he'd like to waive conflict, the Florida bar, subject matter jurisdiction, and the due process. Well, if we waive all that, what is our country? How can you waive it? It's unwaivable. So the fundamentals are just so bad. I implore you to look past my defects and realize what is at issue here. Thank you so much. I don't want to go over. Thank you.
Well, don't worry, I'll let you finish it up. You have gone over, but we're at a good stopping point, so everything is well. I thank you all for your presentation today. The panel and I hope you all stay well in this interesting time in which we live. And that will, I guess, conclude this case. And I guess they bring you back over to the other location, wherever that is located. And that concludes the court's docket today. I thank you all again.
Thank you, Your Honor.
Thank you. Thank you, Your Honor. I think so. I recorded it.
So what happened in the end? Nothing?